Can I just say something about Andrea?
Good morning, everybody. Happy Monday. Happy Monday. Are you guys getting summer yet? Are you enjoying summer? I got summer over here. I'm like in full summer mode. Kind of early this year, but I'm not going to argue. I'm going to take what I can get when it comes to long days and nice time being outside and all that. But hey, we got court to watch today. We've got the WebEx link here all ready to go just as soon as Judge Graf decides to get things rolling. So we will patiently await that. Oh, but boy, in the meantime, there have been a few developments as well. So let's just kind of get us oriented on where we are, because it is Monday. I don't know about you guys, but a little slow to kickstart sometimes. Need to kind of gently rev the engine to be able to operate at the function that we would like. So what we have today are rulings on outstanding defense motions. First motion is to they're requesting a hearing, an order to show cause hearing on whether Chris Ballard, prosecuting attorney, is in contempt of the gag order for public statements that he made about the ATF ballistics testing, for lack of a better way to put it. It's really tool mark analysis. And then the other motion relates to whether portions of the preliminary hearing are going to be closed to the public and whether the exhibits are going to be made publicly available. So as usual, I will go ahead and give you guys my predictions on this and where I think it's going to go. We heard the argument on this at the last hearing, so if you want to get kind of caught up on what the positions are, you can go back and check out that one. But my prediction is that the judge is going to allow the hearing on contempt. He's going to let them put on evidence and make the record that the defense feels that they need or want to make on this issue of the gag order. I say this just based on largely Judge Graf, from my perspective, has really given a lot of benefit of the doubt to the defense, a lot of grace to be able to make their record and defend the case the way that they think it needs to be done. Obviously doesn't mean he's giving them everything that they want, but he's giving them an opportunity to make a fair ask and to create a fair record for future review, which obviously this is a courtroom. Everybody at some level is thinking about that kind of down the road possibility. So I think he's going to allow them the evidentiary hearing. It doesn't mean he's going to find Mr. Ballard in contempt, but he's going to let them put on the evidence and see. I think the only way he doesn't get there is if he looks at the statements on their face and says there's nothing about this. This can't be contempt. This doesn't violate the order. This is consistent with the professional rules. Something like that as a matter of law. So that's possible. But when I looked at those statements myself, we looked at them at the last hearing as well. Some of them are kind of close to the line. They don't verbatim hit all of the requirements that the rules, say that public statements about pending matters are supposed to include. So it's close to the line. And because of the fact that it's close to the line, that's one of the reasons I think he's unlikely to decide it as a matter of law. Let them go ahead and make their record on the evidence and then proceed accordingly, just depending on what the facts show. So that's my prediction on the gag order. Now, the preliminary hearing is a little bit of a tougher call. As far as closing any part of the preliminary hearing, that I think is unlikely. And the defense even backed off of this argument at the last hearing. They kind of recognize that's a bit more of an undertaking to kick the public out of a presumptively open courtroom than it is under what is some not really very favorable case law when it comes to exhibits. There's like a distinction between what the standard is to kick the public out of the courtroom versus the standard to at least temporarily not let the public see certain exhibits. And part of the reason I'm concerned about this is because we don't have, like, even the media, which is kind of like, oh yeah, we don't care about the exhibits. We're not going to try to get copies of them. Like, what? Because the state is here telling us we're going to go through this preliminary hearing and they're not going to publish these exhibits in a way that would make them publicly accessible, that would make them visible to the audience in the courtroom, to the gallery, to the cameras for those of us who are likely to be watching at home. They just want to put them in the record so that the judge has them available to decide, but not share any of that with us. So if we're not able to get copies of those exhibits, we're not going to know what the judge relied on to be able to make his decision one way or the other. And so this is kind of a, from a philosophical standpoint, it is, I suppose, kind of an interesting question, because legally there's really no dispute that anything that the judge relies upon for making his decision, adjudicatory decisions about the case, there is a pretty strong presumptive right of access to the public to be able to see that, but not necessarily right now. Don't necessarily have the right to see that right now. So with nobody really advocating for the kind of, maximalist access position here, that, we the public should get to know what they're relying on to decide there's probable cause to go forward. And we should get to know that now, not have to wait until after the process has unfolded and there's already been a trial and all this stuff. Then we're back in the position where we're kind of hoping that Judge Graf will be the advocate for the public on this. Nobody, even the media is kind of like, we don't really care. We don't really need to know. Well, that's not very helpful for those of us who do think it's kind of important to let the most interested faction, those people who really are interested in the ins and outs and the details of the case. And this is not a large minority or large majority, of people watching. It's very much a minority of people who take like this degree of interest in criminal cases. Nobody's advocating for the argument that we should have the right to know at this point in the case. So I think based on that, it's unlikely he's going to close any part of the preliminary hearing, at least not ahead of time. Where they kind of left it was because they have to make extensive findings, under the U.S. Supreme Court case law for excluding the public from a criminal process. They would kind of take that, bit by bit, take it as it came up in court, which is a little annoying and inconvenient, but kind of how you got to do it. If the exclusion of the public needs to be as narrow as narrow as possible to achieve whatever goal you're seeking to accomplish by kicking the public out, then yes, it needs to be very narrow, and it doesn't tend to fit well with the kind of just blanket, type of decision that can be made ahead of time. But the exhibits is going to be a closer one. The parties have relied on this Utah Supreme Court case, State versus Archuleta, which stood for the proposition that yes, the judge has the authority to not allow the public to access the exhibits from a preliminary hearing. Now, the issue I had, and like part of the reason why I was a little irritated that we didn't get more advocacy for the public's position on this one, is that I'm not real sure that Archuleta is still good law on this particular issue. And the reason why is because it preceded the adoption by the Utah Supreme Court of all of the rules that we've been dealing with throughout this process when it comes to privating court parts of the court file. And so Utah has this extensive set of rules. 4-202, I'm pretty sure is the main one, although I kind of forget off the top of my head now. But they have these rules of judicial administration for handling the different documents. They have all these different levels of privacy and who gets access to what and things like that. Because there are sensitive materials that end up in a criminal case file. But the presumption is generally we get to see it unless it fits within one of these exceptions. So my argument would be, you got this whole rule system that needs to be followed that represents the sort of new decision making, the new thinking of the Utah Supreme Court vis-a-vis public access to these materials. So to the extent that Archuleta is a case from 10 or 20 years before that, saying reaching a different conclusion, that's not necessarily binding anymore. So I would be arguing the court needs to go through the rule process, just like it would when we have these, sealing hearings on should one of these motions remain private or whatever. They should have to go through that whole process to justify keeping it from the public with the exhibits, just like they have to do with any other document. But I'm just over here watching on the sidelines, not advocating. So nobody has made that argument to the judge. So I don't expect him to rule on that, even though personally I think that would be the right ruling. So that's what we are waiting for this morning. Gag order. Are we going to have another hearing? And primarily with the preliminary hearing, exhibits. Are we going to get to see exhibits, or is the judge going to seal them off from us? So that remains to be seen. Now, in the meantime, we'll look at this because the hearing is probably going to get going in just a couple minutes here. But we have had a little bit of a development in the case over the weekend. Some of you may have seen that I think it was on Friday, late on Friday, they filed their notice of intent to seek a interlocutory review to the Utah Supreme Court. They want the Utah Supreme Court to evaluate Judge Graf's order where he denied their motion to just blanket ban the cameras. He said, no, you got to do this on a case-by-case basis. And so the defense is saying that's wrong, and he didn't address the constitutional issues that we raised. So we want the Utah Supreme Court to look at that issue now. And what just happened within the last 24 hours is the defense has now also filed a motion to stay the case while they wait for that appeal to kind of work its way through the process. So we can talk a little bit about that and what that means and kind of the likelihood of where this is going to go. Given the timing of this request to stay, I'm not quite sure how the court is going to handle it. So we may get a little bit of a housekeeping type of conversation here because we're just a few weeks from the preliminary hearing supposed to be starting. And this motion is specifically asking, among other things, but specifically the preliminary hearing, don't let it go forward until the Utah Supreme Court decides if we're going to uphold this rule that the cameras can ask for permission to come in. And so like the time for them to be able to brief it and argue it and decide it and stuff is a little bit truncated given the time the hearing is supposed to take place. So I would expect they would want to accelerate that, decide it on a little bit of a faster track than ordinarily they might normally decide these kinds of motions. Because it just seems like a bad idea to have to subpoena people and have all your exhibits arranged and have Tyler being transported over to court and everything. If you're just going to rule at that hearing that we're not going to have the preliminary hearing go forward, we're going to stay it, like the defense has asked for. Now, I will say I don't expect the judge to do any of this. I don't expect the appeal to win. Well, I don't expect the appeal to be granted at all. It's the kind of issue that I think they can certainly appeal it, but they'll be required to wait until the case is over. But then as far as the stay as well, it seems very unlikely to me that that's going to be granted. It is discretionary with the judge. So it's kind of a judgment call for him. And it's quite disruptive to the process to just, put the brakes on and make everything stop. You can certainly do it if he's got a good reason for it. But I would expect that he's going to want to be facing a situation where like there's a pretty good likelihood that something could happen that could unsettle the process down here in the trial court. some possibility of the Utah Supreme Court accepting review, some type of, likelihood that they would reverse his order. And to me, these things seem pretty remote. And so since it's pretty remote, it's not a high risk. I don't think he's probably going to give them what they're asking for. But we'll take a look at it and maybe talk about it a little bit more specifically after the hearing gets underway. So we do have the WebEx link here. Folks are present, but nothing is quite happening yet. They are starting to see like faces and stuff from some of the folks who were there, but gonna take a minute still, but we'll be ready for it. So yeah, just oh, and I know I know there's like a lot about the cameras and just the continued defense strategy being to battle the cameras. I have so many thoughts about that. Continue to just think about this from a strategy standpoint and kind of what it means and signifies and so forth. Mindy Ann's just gifted a bunch of memberships. Thank you so much, Mindy Ann. I'm going to look forward to seeing the chat all turn green. Yeah. Boy. I'm not surprised that the defense is taking such a hardline position against cameras. And I'll tell you why. I mean, I've talked about this before, that when you're a defense attorney, it's not that you don't ever have an innocent client, a factually innocent client, somebody who like literally did nothing wrong at all, and or legitimately has a rock solid like self-defense claim or something like that. But it's not the norm. It's not common. If you're like in the trenches at the criminal docket at your courthouse, which I continue to encourage everybody, go check out your local courthouse sometime. Seriously, like just go sit in on a criminal docket, watch the volume of cases that go through and like how they get handled and stuff like that. You can just learn an awful lot about the process from seeing it. Not so much these cherry-picked cases that get all of the attention, but just the everyday volume that gets processed through. That's far more of what the norm is in court. And so what you find is most of those cases, they are arguments around the edges. They are not like my client did nothing wrong, the evidence is wrong, the evidence is fabricated. It's arguments about things like, you've overcharged this person. There's a different charge that fits better. There's an alternative resolution to prison that might be appropriate in this situation. You're very often not litigating, we're going for a full acquittal on everything or nothing. And so what that means is that, you're quite a bit of the time dealing with people who did something probably not very good. May not be exactly what they're charged with, may not be, worth life in prison or whatever, but, it's not good. It's not good. It probably isn't going to make them look good. So the evidence tends to not be helpful. And so because of this, I think it's pretty normal that defense just kind of characteristically is not real friendly to the press. Nowhere near the amount that the prosecution is. Prosecution is happy to go out and talk about, here's our probable cause and here's our what we filed, and we think we're going to convict him, and so on and so forth. Far less common for the defense to be real media engaged like that. And the reason why is because generally, it's not going to be that favorable. Cameras are favorable to the defense in terms of like revealing weaknesses in cases and in evidence and witnesses and so forth, in probably a minority of cases. And so you just think about it. If you're a defense attorney and you have just kind of an average caseload, and the general tendency you're going to want, given that, is not scrutiny. You're going to want less scrutiny rather than more. It's going to be the exceptional case where you're like, holy crap, there's all this misconduct. There's all this, crazy stuff with evidence, not, being destroyed, not being turned up, major problems with witness credibility, things that work very strongly in your client's favor. Those are reasons why it's beneficial for the cameras to be there, because it helps spread the word publicly that, there's serious issues here with the alleged.
Good morning.
Guilty
Court is
client.
now in session. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Matt Grunander, Ryan McBride, and Christopher Ballard for the state, Your Honor.
Good morning.
Good morning, Your Honor. Richard Novak, Stacy Visser, and Michael Burt for Mr. Robinson. I believe Ms. Nestor is on an airplane somewhere, so she's not with us today. And Mr. Robinson should be appearing audio only from the jail.
All right. Mr. Robinson, are you with us? Thank you. Good morning to you all. The court now issues its rulings on the two outstanding matters that we recently heard. I'll start with the ruling in order addressing the defendant's motion for order to show cause. Defendant Tyler Robinson filed a motion for an order to show cause, docket 504, seeking an order requiring Utah County Attorney Jeff S. Gray and Deputy Utah County Attorney Chris Ballard to appear in court and show cause why they should not be held in contempt for violating the pretrial and trial publicity order originally issued on September 16th, 2025, and amended on December 15th, 2025. And as I'm reading this, I'm going to be filing my written rulings, and so I'm going to omit the citations to the dockets in case, but that will be in its full form. The motion is fully briefed. The court heard oral arguments on May 19th, 2026. Having considered the papers and the oral arguments, the court now rules and orders as follows. Defendant alleges the conduct occurred outside the immediate view and presence of the court. Thus, Section 78B-6-302 sub 2 requires defendant to file an affidavit or statement detailing the facts constituting the contempt, which statement, together with the subsequent court order, forms the basis of the contempt charge. Defendant's April 16, 2026 declaration of counsel in support of the order to show cause satisfies that requirement. In the declaration, defense counsel identifies the alleged conduct and provides specific examples. Defense counsel asserts that Utah County Attorney Jeff S. Gray and Deputy County Attorney Chris Ballard violated the court's pretrial publicity order by making specific statements to various news outlets, including TMZ, USA Today, Fox News, Political Facts, and others. Accordingly, the court grants defendant's motion for order to show cause. The issuance of this order reflects a determination that defendant has made a sufficient preliminary showing under Utah law to warrant further proceedings and does not constitute a finding of contempt. An evidentiary hearing will take place during a portion of the previously scheduled June 12, 2026 proceeding. The purpose of the hearing is to determine whether the evidence establishes the elements of contempt, namely whether the Utah County Attorney's Office and its representatives knew what was required under the court's pretrial publicity order. The respondents had the ability to comply with that order, and the respondents, by making specific statements to various media outlets, intentionally failed or refused to comply with the pretrial publicity order. Because defendant seeks an order for civil rather than criminal contempt, and because the focus of the claims is on the potential impact the disseminated statements may have had on the potential jury pool, the court respectfully declines to issue an order compelling the Utah County Attorney's Office to produce the requested discovery. Each side will have 1 hour and 30 minutes to present evidence, after which the court will take the issue under advisement and issue a ruling at a future date. This is the order of the court. And that concludes the first ruling by this court. Turning to the second issue. This is regarding defendant's motion in limine to close portions of the preliminary hearing testimony and seal preliminary hearing exhibits. Defendant Tyler James Robinson seeks to close portions, if not all, of the preliminary hearing and to seal preliminary hearing exhibits. The motion has been fully briefed and oral arguments were heard on May 19th, 2026. At oral arguments, the parties agreed that neither the public nor the media should be permitted to inspect or copy exhibits presented at the preliminary hearing, except as published in court as part of the hearing. With the issue of the exhibits resolved, the court turns to the closure of the preliminary hearing itself. The public and the media enjoy a presumptive right to access court proceedings, including preliminary hearings. A party seeking to close a preliminary hearing must show that adverse publicity traceable to the open hearing poses a realistic likelihood of prejudice to a fair trial to overcome this presumption. The party seeking closure must also show there are no less restrictive alternative means to ensure the integrity and impartiality of the jury. Public access to judicial proceedings also serve in an important role in maintaining confidence in the fairness and transparency of the judicial process. This court finds these showings have not been made here. First, the motion does not identify with sufficient specificity that the evidence, if presented in a public proceeding, would create a realistic likelihood of prejudice to defendant's right to a fair trial. Despite receiving notice of the state's witnesses and exhibits for the preliminary hearing, the motion raises generalized concerns regarding hearsay and the expert reports without identifying particular evidence warranting closure. Furthermore, much of the evidence the state indicated it intends to offer during the preliminary hearing is already in the public arena and was identified in the information and probable cause statement. The possibility that evidence introduced at the preliminary hearing may later be ruled inadmissible at trial does not, standing alone, bar the public from the courtroom. The court, however, acknowledges defendant's pending motion in limine to preclude 1102 evidence and reserve ruling on that issue until the matter has been fully briefed and heard. Even assuming specific evidence has been identified that could present a risk to defendant's constitutional right to a fair trial, if publicly disclosed, the motion does not establish that a no less restrictive alternative remains available. Several methods remain available to protect the defendant's right to a fair trial, including enlarging the veneer of potential jurors, utilizing detailed juror questionnaires, and conducting thorough voir dire, all methods routinely used to safeguard a defendant's constitutional rights. For these reasons, the court respectfully denies defendant's motion. This is the order of the court. Counsel, I will go ahead and sign these orders and it will be uploaded to the docket today. And with that, I believe we have our next hearing on June 12th, starting at 9 a.m. And that is in person. I'm anticipating Mr. Robinson being present, and we will adjourn until that date.
Your Honor, may I just ask the court one scheduling question?
Absolutely, Mr. Novak.
So we have these two matters on June 12th. One is argument on the motion that the court just referenced, and one is the order to show cause hearing. Did the court have a preference for which of those two matters it does first and which it does second?
Let's go ahead and do the order to show cause first and the evidentiary hearing, and then we'll turn to the second matter. Thank you for that
Thank
question.
you.
Mr.
That's fine.
All right. Anything further from the parties?
Nothing from the state, Your Honor.
All right. Thank you to all parties. I wish you a good rest of your day. Court is in recess.
Well, nice, short, and sweet hearing there. Goodness. Well, sometimes I don't like being right. So we are going to get the evidentiary hearing pretty much as anticipated. He's like, the allegations alone are enough to raise a question of whether there was contempt here. So he's ordering the hearing so that they can evaluate if there was an intentional violation. This is where I think the prosecution is going to likely escape a finding of contempt here. I mean, first off, gotta just always take things in the context of the kind of political environment of the courtroom. I don't mean this obviously in a big picture politics kind of way. I just mean this in terms of like, just this is the reality of how people interact in courtrooms and stuff like that. He doesn't want to find them in contempt. Judge is typically not going to want to do something like that. It's just, it opened doors, it creates problems, but then it just goes against the kind of congeniality that they enjoy having in courtrooms where you're always, dealing with the same personnel. I mean, I'm sure that Judge Graf sees Mr. Grunander and Mr. Ballard and all these guys, other cases in front of him, and that's kind of normal. Obviously not saying that's right or that's what the law is or anything like that, but just that's kind of how things go in the courtroom. So I think he's likely to just be a bit resistant to the idea of finding them in contempt in the first place. But this requirement that they intentionally violated it, the willfulness component of contempt, I think is where they have the most wiggle room, and because that's where the state has their built-in defense that they've already kind of pitched to us, that, look, this was a fair response. This was not an intentional violation of the court's order. This was an effort to exercise our rights under the rule that says we get to respond to information that's, incorrect, that is prejudicial to us, that's put out in the public square. So it's not that, like, yes, I knew there was this order and I chose to ignore it. The situation is, yes, I knew there was this order and I tried to navigate around, the restrictions that it imposes, but to at the same time stay in compliance with it. Maybe they did, maybe they didn't, but I think that's going to be the general nature of the defense. And so even if, maybe it's strictly against the language or the intent of the gag order, were they like really like being bad, ignoring the court? I think he's unlikely to make that finding. So obviously a lot could happen, depends on the evidence that comes out and so forth. But what's going to come out? Jeff Gray is going to testify. Chris Ballard will testify. I don't know who, if anybody else would testify. You're not going to like subpoena Fox News or TMZ into court or anything like that. Although I'm pretty sure, I'm just going to check real quick. Not sure exactly how strong Utah's reporter's privilege is, but it looks like it's a fairly strong one. Nearly absolute protection for confidential source information and qualified protection for non-confidential news gathering information. So yeah, you basically, anytime there's a reporter shield law, you're going to have a real hard time compelling some reporter to come into court and tell you who told them what and under what circumstances and things like that. So this is going to be, I think, a little bit of a repeat of the same sort of thing that we saw back when they were trying to disqualify the prosecutor's office. And so we got the prosecutors on the stand to testify about how everything was just fine. And there isn't really a lot to challenge them with on it, since the defense isn't getting access to their internal communications, their emails and stuff about how they were going to conduct this response. Then they aren't going to necessarily have anything to contradict whatever the witnesses have to say about their own thought process and motivations and things like that. So I expect it to be kind of like what we saw before, where they, ask them a whole bunch of questions and they have the opportunity to defend themselves, and there's not really any way to challenge that. And so it will kind of, not create a real factually difficult record to be able to sort through. But that's where we're heading on June the 12th with that. Doesn't look like we're going to get the exhibits. Doesn't look like we're going to get the exhibits. We're going to get to hear the testimony, and the public's going to be able to be present still. Doesn't foreclose them once again from, in the course of the trial of the hearing, as things come up, being like, "Oh, judge, we need to close the courtroom for this, and here's the showing," and so forth. But pretty clear the judge is recognizing that there's a pretty high standard that you have to meet to justify doing that, and that's going to be particularly difficult to meet in light of the fact that we don't even have a trial date yet. We are probably still years from trial, and one of the remedies that you have, I guess, so to speak, one of the protections, the things that mitigates against this information tainting his right to a fair trial just by virtue of it being out in the public, is that years are going to elapse before the case will be tried. And so prospective jurors coming in, if they're even paying attention to this at all, may very well forget, just not even pay much attention to what's happening in these types of proceedings. And so they have all of those jury selection methods and big questionnaires and call in extra people and things like that to try to mitigate any influence that prospective jurors may have experienced if they've paid attention to these proceedings, by just weeding out the more attentive ones, or the ones that know a little too much detail about the case. But nobody advocated for the exhibits for us, did they? And so he just treated that as, hey, everyone's in agreement, so it's resolved. And that's unfortunate. That's unfortunate, because last time they did that, he didn't accept their stipulation. It was when they were in the courtroom on that motion to disqualify the prosecuting attorney's office. They were trying to keep identities under wraps. And so this was before we knew it was Mr. Grunander and his child that were at issue. And so everybody had agreed, sure, Mr. Grunander, we'll seal that part. We'll kick the public out and do that part of the hearing without the public present. And the judge said, no, not going to do it. He went ahead and allowed it to be confidential for the child, but not as to Mr. Grunander. So he rejected the stipulation in that situation and favored the public's right to know and to observe. But unfortunately, when it comes to the exhibits, it doesn't look like it's going to be quite that favorable. So unfortunate. And part of the reason why this troubles me too is just because the prosecution, from the statements that they've made, the arguments that they've made on these issues and stuff, they seem to have made it clear that they're going to present the case in a way that kind of minimizes what the public sees and what the public has access to. Not gonna publish the exhibits, not gonna let us see them and things like that. Taking a minimal approach basically to getting what they need into the record for the judge, but not necessarily, going out of their way to make sure that we, the public sitting at home, understand exactly what and why is happening. So that means I don't know how much the testimony is going to spell out real clearly. What are we dealing with here? How much is they can theoretically just rely a whole bunch on the exhibits and call their witnesses. I'll just kind of give you an example. They would call the witness to describe the part of the video canvas, the part of the investigation. Here's what they did. Here's who was involved. Here's who they contacted. Here's what they collected. And then here are these things introduced into evidence. Here's what we found. And they could just end it there, right? Admit the video. Judge, you have the video, go and watch it. If we were in more of a trial setting where this is all kind of playing out with a little bit more of like the public attention playing a role in it, then you would take that further. You would ask them to describe what is it on the video? Why did you think that that was important? And so even if we don't actually see the exhibit, through the testimony and the questioning about why does it matter, we would learn a lot more about the nature of it. So the signals that the prosecuting attorney has been giving, we're not going to, show this. We're going to, try to minimize the information, all that kind of leads me to think they're going to take that more minimalist approach of just letting the judge kind of connect the dots. Here's the evidence, judge, you put the pieces together. So we'll see. It remains to be seen. So we will be back then on June the 9th or June the 12th at 9 o'clock. Let's now take a look at this latest filing that I said we would take a look at. Here we go. They're moving to stay. This is what we were talking about up at the top. Moving to stay, pending interlocutory review. So I had a bunch of questions over the weekend about this appeal and kind of what it means and what that process looks like and when will they decide and things like that. So there has already been one interlocutory appeal attempt in this case. And this was back when this was like at the end of the year, 2025 going into 2026. Judge Graf had denied the defense's motion to let Mr. Robinson be in court without shackles. Allowed him to be in civilian clothing, but said the shackles are going to stay, just cameras. You can't photograph them or show them or anything like that. And so they went through this process already at that time. They just did it kind of under seal privately. I don't know. We didn't see this as it was happening. We only kind of saw it after the fact, after everything had already taken place. So an interlocutory appeal is one that is taking place before the entire case is done. The normal presumption is that you wait to appeal issues until everything is over. Because what we don't want to do is to piecemeal a case and have to kind of decide every issue as it happens. Appeals processes are not quick. They have to compile the record. They have to prepare the transcripts. They have to send it all up to the reviewing court. The reviewing court has to research it. It has to be briefed. It has to be decided. So best case scenario, this takes months if you go through an appeal on an interlocutory basis. And the reality is much more like, anytime you're talking about an appellate court, you're probably talking about years in terms of your time frame. So like minimum a year, it would take potentially to go through these things. And so if you can just appeal everything as you go, then why would you ever appeal at the end? You could just keep kicking the can down the road, keep appealing and stuff like that. Court doesn't want that. They just basically say, no, the priority is for efficiency's sake. We're going to get through the trial. Then you can appeal everything at the end, unless there is something that is like so obviously wrong, so critically important in the overall conduct of the case. It's just going to be irremediable if we don't correct it. Very limited exceptions for being able to appeal things like this before the whole case is done. So it's once again very high standard that needs to be met. What they do procedurally is they file a petition in the Utah Supreme Court. Because this is a death penalty case, everything goes automatically to the Utah Supreme Court. They just cut the Utah Court of Appeals out of the process entirely. They file a petition with the Utah Supreme Court asking them to consider this appeal. And the very first step is the Utah Supreme Court decides, are we going to entertain this appeal or not? Because they don't have to. It's interlocutory. They can say, no, it's not important enough. You're not likely enough to win it. It's not likely enough to affect the overall flow of the case. So you can just wait until the case is over to appeal this particular issue. And so that's what they did with the previous appeal, the appeal of the shackles. He petitioned to the Utah Supreme Court, said, please review this issue right now. It's really important because he's going to be shackled throughout this proceeding. And so if it's a violation, and the Utah Supreme Court said, nah, we're not going to consider it. It took them approximately 6 weeks during that first process to review the petition. The state also does get to file a response why they think that review is not appropriate in this situation, shouldn't be granted. So it's briefed. They decided, they issue an order saying we're denying interlocutory review. Took about 6 weeks last time for that to happen. So that's what this process is going to involve as well. They have filed a petition to the Utah Supreme Court. They're saying, please review this question of whether the cameras should be blanket banned from the courtroom. Or, I mean, it's legally, I got to think about these things, as a lawyer in terms of the legal standard. It's like even more kind of narrow than that. It's whether basically Judge Graf abused his discretion by declining to blanket ban the cameras. This is kind of a tough position for them to be in my view. And because interlocutory review, again, typically requires the error is really obvious. It's so well established. This is so far outside the norm of what reasonable judges reading the law and interpreting it and applying it could come up with in the situation that it warrants being fixed immediately. And you don't have that here. You don't have crystal clear law that's on the defensive side that says, yes, absolutely, the judge must ban, cameras on a blanket basis under, XYZ circumstances. There's nothing like that. So it's highly unlikely to reach that kind of standard that is always going to apply when you're trying to appeal things early. But they filed their petition, so the state's going to have an opportunity to respond. I think it took them a couple of weeks last time, maybe 3-4 weeks. I suppose I could look at the docket, but I didn't anyway. And then a few weeks for the court to issue its decision, said, no, we're not granting review. So same, likely similar processes is going to unfold here. So that's the interlocutory appeal part of it. That's what came out over the weekend. But now this is new this morning. This is the motion to stay while all of this is going on. So doubling down, not only are we trying to get the Utah Supreme Court to look at the camera issue right now before the case goes any further down the road, but we also want to stop, halt, pause, call time on the whole case while they wait for the Utah Supreme Court to make that decision. And so the argument here is pretty straightforward. They're like, we're about to have a preliminary hearing. And so if it turns out that cameras would be some kind of a due process violation, then if you don't stay this preliminary hearing or this process, then we could have this interlocutory review and the Utah Supreme Court could say, yes, Judge Graf should have blanket banned the cameras, but then we've already had the cameras in there for the preliminary hearing. So the harm is already done. It puts them in a position where, from their perspective, you can't fix it anymore. You can't unring the bell once things have already gotten out there into the public record. So wants to continue it. It's brought pursuant to Utah Rule of Appellate Procedure 8th and grounded in the 5th, 6th, 8th, and 14th Amendments to the U.S. Constitution and Article 1, Sections 7, 9, and 12 of the Utah Constitution. Once again, these guys are constitutionalizing all of these issues. And there are some reasons for that. Going a little deeper into sort of what I am seeing in this whole defense strategy of challenging the cameras in the first place, which is that this is largely a preservation for future federal review undertaking. And that's really it, in my opinion. But we'll talk about that a little bit more too. So factual grounds. Due to the overwhelming negative publicity generated by the electronic media coverage of Mr. Robinson's case, he sought an order from the court prohibiting further EMC. Forget about the record of all of the press that is negative to the state, negative to Erica Kirk, negative to Charlie Kirk himself. It was it's taking me back to that hearing when Dr. Edelman was testifying about his survey, his media survey, and kind of what he found in terms of, like 53% of people had a negative opinion. I'm like, this is so favorable. I mean, when we compare this to Koberger and the survey they did there, where it was like 99.5% of people have already decided he's guilty, can't be convinced otherwise, I was like, wow, this survey to me is showing a really open-minded prospective jury pool. But, it's advocacy. It's fine. The state's going to point that out if they think they need to. But just always kind of funny to see the characterization. So overwhelming negative publicity that hasn't really poisoned the jury pool anywhere nearly as bad as Latah County was in Idaho. The state of Utah and the news media objected to Mr. Robinson's request. An evidentiary hearing was held on April 17th, 2026. The court limited each party to 2 hours to present argument, examine witnesses, cross-examination, and redirect and respond to inquiries from the court, as well as reserve time for rebuttal. This is kind of interesting because they're making a little bit of a record of limitation. The court put limits on it. So just another little thing that might play into some kind of challenge. Like, well, maybe we're 10 years down the road and we're on federal habeas review and there's an issue about the sufficiency of the record. This can come up. Does the court have enough facts to be able to decide the particular issue that's being presented? And so then the strategy, gets developed about, do we rely on the facts we have in the record? Do we ask the federal court to take additional evidence? If we need the federal court to take additional evidence, then we typically have to show that there is a reason why we couldn't have done that in the lower court. That's what this word right here is doing. It's saying, hey, the court limited us. So to the extent you, 10-year down the road, federal habeas court, are interested in hearing new evidence or getting more information about this situation, this is why you don't already have it right here, because the court limited our ability to be able to make that presentation. In the time provided, Mr. Robinson introduced into evidence truncated testimony and written reports and declarations by Dr. Ruva and trial consultant Dr. Brian Edelman, two lengthy PowerPoint presentations, one of which contained multiple examples of prejudicial electronic media coverage and of an instance where the state had violated the court's publicity order. All of the studies cited in Dr. Ruva's declaration, supplemental report, and PowerPoint, over 6,000 pages of transcripts of the electronic media coverage in this case, all of the electronic media clips referenced in the motion, the declaration of Mr. Robinson's lead counsel setting forth threats she had received as a result of the publicity, and the declarations of various witnesses who objected to having their images or testimony broadcast or experienced adverse effects from pretrial publicity. On May 8th, 2026, the court issued its camera ruling denying Mr. Robinson's requested relief. The denial relied on the court's interpretation of Utah Rule of Judicial Administration 4-401.01, but failed to address Mr. Robinson's constitutional arguments. The court found only that a blanket ruling prohibiting EMC was not permissible under Rule 4-401.01, leaving open the possibility of either or both parties challenging EMC prior to every hearing. However, the court outlined a procedure for doing so that deprives the parties of any meaningful opportunity to object, to be heard, and to seek review of an adverse order to a higher court before the damage is done. That's quite a characterization. Remember what Judge Graf did? He said that the media has to put in their request for electronic media coverage now, like weeks before a scheduled hearing is coming up. And they have to do that because defense are going to need to have an opportunity. It's like specifically to give them the opportunity to object to a particular hearing being televised. And so they would be able to state their objection. The media and the state would be able to respond. The court would have an opportunity to resolve that and issue the order or not before the hearing is scheduled to take place. So rather accommodating. Nothing in the rule says the media has to do this weeks ahead of time. And typically they often wait until maybe just a couple days before. It hasn't really been that big of a deal. So from my perspective, the court's modification was very much defense friendly here. It's entirely for the purpose of giving them a chance to be able to object to cameras coming in on a case-by-case basis. But they're not characterizing it that way. Of course, they can't characterize it that way because it kind of makes them not really aggrieved and not really showing a good justification for why the Utah Supreme Court should be alarmed at this process that Judge Graf has set up. Mr. Robinson filed a petition seeking interlocutory review of the court's camera ruling on May 29, 2026. In his petition, Mr. Robinson asked the Utah Supreme Court to grant interlocutory review for 3 reasons. 1, review is necessary to protect Mr. Robinson's fundamental federal and state constitutional rights to a fair and reliable trial by an impartial jury at both phases of his capital case. 2, it was error to deny Mr. Robinson's requested relief without reaching the constitutional issues. 3, this court's imposition of severe procedural restrictions violates Mr. Robinson's state and federal constitutional rights to procedural due process. Weird. Severe procedural restrictions. They didn't move to reconsider. Now, I don't know. I should probably look up. What the kind of standard is for motions to reconsider in Utah. Just to see if there is anything. So they definitely have them in the civil courts. And typically, if you can do it in the civil court, you can do it in the criminal court, unless they specifically tell you you can't. And so if you think there's a clear error, legal error in the decision, you can raise that in a motion to reconsider, bring it to the court's attention, give them a chance to fix it. They never said, Judge, this procedure you're imposing where the media has to request electronic media coverage weeks in advance so that we can object. This is harmful to us because why? Because why? And nor is that really spelled out here exactly how this is harmful. But that's the allegation. With a lengthy preliminary hearing set to begin in 5 weeks and 4 justices of the Utah Supreme Court in transition, it is unlikely that Mr. Robinson's petition will be resolved prior to the July 6th through 10th, 2026 preliminary hearing. This leaves Mr. Robinson in the untenable position of proceeding with a preliminary hearing with EMC attendant in violation of his constitutional rights, while the petition seeking to prevent this harm remains pending. It is for this reason that Mr. Robinson seeks to stay proceedings pending the outcome of his petition. They have this footnote here. Notably, under the current order, Mr. Robinson will not know if the court has limited EMC based on his objection until the day the preliminary hearing begins. Okay. I'm not sure why that matters, but that is the risk. Yes, that the hearing will go forward with the cameras, but there's a so what, that's kind of on the heels of that. So what? So what? Now, if there's a really high likelihood that the Utah Supreme Court is going to overturn that and say absolutely not, the court should have blanket banned the cameras, then the so what, is pretty obvious. Well, cameras aren't going to be allowed, but they're going to be forced to go through this hearing with cameras. The problem is, of course, that's not likely because the law is really not on his side on this particular issue. This right here is really just the most, I think, important part of the whole argument. It lies within the inherent powers of the court to grant a stay of proceedings. It is a discretionary power, and the grounds therefore necessarily vary according to the requirements of each individual case. Here, the court should exercise its discretion in granting a stay in order to prevent the prejudice to Mr. Robinson and the violation of his constitutional rights that will inevitably result from the continued EMC of these capital proceedings. The legal standard is it's up to the judge. And as long as the judge acts with some kind of reasonable basis, he issues a ruling that has some justification that ordinary people can understand. No, I don't think it's likely that the Utah Supreme Court will grant review. No, I don't think that, there's likely to be harm that results. Then that's going to be within his discretion. Abuse of discretion is a very, very difficult thing to show, that a judge who gets to have a wide range of options depending on what he thinks is reasonable under the circumstances, to show he picked the wrong one, that's really tough. And so it usually requires something like he's specifically relying on a wrong interpretation of law, or he's relying on something that's obviously inappropriate, not a valid basis, or something like that. Not real common, not real likely to be reversed. And so that means, bottom line, this is largely up to Judge Graf. And does Judge Graf think this is going to be reasonable and necessary or not? He says, in granting interlocutory review of a motion to change venue, the Utah Supreme Court in State v. James noted the important purpose of interlocutory appeal as affording the opportunity to review the denial before the error committed would be prejudicial to the defendant. And in circumstances where prejudice may be prevented, like here, the Utah Supreme Court aligns with the United States Supreme Court that reversals are but palliatives, and that the cure lies in those remedial measures that will prevent the prejudice at its inception. The same reasoning supporting the grant of interlocutory appeal supports staying these proceedings pending the outcome of Mr. Robinson's petition to prevent the errors committed from prejudicing Mr. Robinson. Strategically, I don't think conflating these two standards, even though I think they're right, strategically, I don't think that's helpful to their position at all, because the judge is already going to know interlocutory review is really unlikely. It's very unlikely the Supreme Court is going to grant this. And so if it's the same standard that applies, then I don't really need to be worried about it. I think, yeah, we just kind of start to go in circles with some of this stuff. because this has been an issue for so long now. There's been so many rulings on it, so many hearings. The judge has explained his rationale, repeatedly over and over again, that it's not clear we're gonna, really move beyond what the basic dispute is here. The basic dispute is, the defense doesn't want any of this stuff publicized before we get to trial. Why? Well, likely because in the overwhelming majority of cases, and possibly this one as well, the actual evidence tends to not be favorable to the accused. If it is favorable to the accused, then you're taking the more unusual, more extraordinary position of, judge, get attention over here, get cameras in here. I'm going to be filing things in my legal filings that identify what these factual issues are, like misconduct by the state or things like that. We're going to be calling them out. We're going to be using them for our benefit. We are going to be exercising our own right to respond in the press under RPC 3.6 to make the extrajudicial statements to correct the things that are already out there in the public record. The state has just made this argument. The defense can certainly make the same ones on their own side. So when press is beneficial to you, that's what you're going to do. But just the reality as the defense lawyer is that oftentimes the evidence isn't on your side. And so if the whole world sees the evidence before there's a trial, much greater likelihood that the whole world is going to have an opinion about the client's guilt or innocence before you get to the trial point. It's just the basic position that the defense is taking. And so that's not new, and that's probably not going to change. It's clearly been a ongoing and persistent part of their advocacy. But we've then also seen just shot down over and over and over again for the same reasons. First Amendment public right of access. A lot of, related considerations under Utah specific rules, Utah camera friendly rules. Not a whole lot in the way of good, authority, legal authority for the defense to rely on when it comes to cameras being a problem of a constitutional magnitude. In fact, the U.S. Supreme Court, came out and said very specifically, it's not a per se due process problem to have cameras in the courtroom. It's a, individualized case by case type of decision. And then the bottom line, we're still years out from trial. We don't have a jury pool, the classic kind of framework to be able to mitigate harm in these types of situations like this, where there's publicity, is to deal with it in jury selection. And so the judge has said repeatedly over and over again why he's not granting the concerns. First Amendment, Utah rules, and ability to address problems with publicity through the jury selection. So the defense is just, kind of arguing it's prejudicial, and the judge has kept saying why he thinks it isn't. And I just have a feeling we're going to be seeing the same argument, going around and around and around over and over, in part because of the immense patience that we see from Judge Graf. He lets them make their case, and he will very patiently shut it down once again. He will simply repeat himself about, the time-honored methods with the jury selection that can alleviate any kind of prejudice from pretrial publicity. They want to ask again, he'll just say it again. Seems to be the routine that we're in. But that's the basic gist of it, as I see it. The defense is arguing the publicity is prejudicial per se. Why? Because people are going to prejudge the defendant's guilt. That's kind of a necessary part of the logic of saying that cameras are per se prejudicial, is because it will make people less able to presume Tyler Robinson innocent when they show up as petty jurors in the trial. And so that kind of takes us to, so why, they don't want the cameras in. Obviously, they don't want the cameras in. The cameras are prejudicial. We have to assume that's because it's not helpful for the world to see the evidence. It's not helpful for Tyler Robinson for the world to see the evidence because they may decide ahead of time that they think he's guilty. So why are we doing all this? There's no realistic prospect that they are going to win at this level in Utah courts on banning the cameras. It's not going to happen. The Utah Supreme Court has already gone through this analysis and they adopted their rule. And they didn't make an exception for capital cases or whatever. They adopted their rules for public access. And part of this is to comply with the requirements of the First Amendment. But some of it is also a policy decision that they believe transparency is generally better. It will give people more confidence in the process, more just faith in that the system is working the way that it's supposed to, and that if it's not, we're going to be able to see it and know so that we can correct it. If everything is, done behind closed doors, then you never know when they're breaking the rules and you don't know that anything needs to be fixed. So they are not going to win any of this in the Utah level. This is all being set up via this due process argument that they're kind of trying to revive this old U.S. Supreme Court case law from, I think it was the 1970s or whatever, the Chandler, Estes and Chandler and all of these cases that they've been relying on, where, back in the day, decades ago, the U.S. Supreme Court was skeptical of cameras in courtrooms. But it's complicated because a lot of their reasons for that in those decisions had to do with just the disruption to the courtroom itself. Like there's cables everywhere and people are running around and it's hard to hear and stuff like that isn't necessarily going to be the case in today's day and age. And when we have a decorum order that says how things are done in terms of the camera operation and stuff like that. But the U.S. Supreme Court has backpedaled from that position anyway, and so since then we've had, big growth in televised trials and in watching televised trials. This is the classic example of what I've talked about many times before about how capital cases are, they are the situations where big picture issues get litigated, things that you think about, this bothers me from a legal standpoint or whatever, or I feel like there's a due process problem here, but I'm dealing with a misdemeanor theft. I'm not going to litigate this all the way up to the hilt and try to get it to the U.S. Supreme Court and stuff like that to make new law on cameras in courtrooms. Those types of issues just tend to come up a lot more in the capital context because you sort of have to do everything. You already know this is going to be under scrutiny by appellate lawyers, by post-conviction lawyers, judges, etc. Everybody's going to be watching what you do. So you need to clear the field, so to speak, of any possible issues. Otherwise, that's an argument for somebody to come back later and say you were ineffective at trial for not raising this problem. So they want ultimately some federal court litigation. They want to have due process litigation over cameras. And from a kind of philosophical, big picture standpoint, should cameras be in courtrooms in criminal cases? It's really what they're gearing up for. And so this is why they keep raising it, and what they're doing is they are trying to make their record and preserve this issue, knowing we're not going to win any of this in Utah. But if Tyler Robinson gets convicted 10 years down the road, we're going to be in a federal habeas court. We're going to be filing a writ of habeas corpus. Somebody is. And that's going to be an opportunity for a different court, a court that has a little bit more of a mind for the development of federal constitutional law than the Utah courts do. The Utah courts, they will interpret federal constitutional law, but it's not their, I don't want to say it's not their wheelhouse. It's just they're not like the primary people that do that. You know, it's the federal court is the ultimate authority on the federal constitution. Utah is going to tend to be more concerned about Utah law, Utah constitution. And when it comes to federal rules, generally they're going to follow the leads of the federal courts on that. So this is an effort to get up to the federal court. 10 years down the road for the court to be evaluating, is it generally, what are the due process implications of having cameras in courtrooms, in criminal courtrooms, in pretrial proceedings? And, is there something about that is maybe new or different from the many times that has been litigated in the federal courts in the past? That means that the situation is changed. The social media era, for example, is, I could absolutely see a scenario where defense in federal court on a habeas type of argument is taking the position that, look, the world has changed since the 1980s, when all of these earlier decisions were being made about public access and electronic coverage and things like that. Because we have the social media era and so much information just moves a lot more quickly, which means misinformation moves a lot more quickly. And just like part of the argument Dr. Edelman had made at the last hearing was how it's harder to avoid a lot of this information. Before, if you didn't want to know about the case, just don't turn on the news at night, and that's fine. But today, so much of our just social and normal life, even our work lives, take place online. And so that makes it a lot harder to just be able to avoid it. If my Twitter feed, well, Twitter's a terrible example, but maybe my Facebook, I don't have Facebook, but many people do. Those of you on Facebook, you go on Facebook to check in on your friends and your family and the people that you haven't seen in a billion years, who kind of pop up out of the blue and find you and stuff like that. Very much part of people's social networks, but through participating in that, the algorithm is also going to feed you these other things. And so Dr. Edelman is pointing out, you get on Facebook, you're going to be more likely to be fed this stuff, particularly if you're a prospective juror in Utah County. Then it's a little bit different than I can just shut off the TV, because that's not limiting my ability to interact with, my social network. Possibly even people do a lot of work online. People have, their professional profiles and things like that. I'm supposed to get on Twitter and do things there, but the feed is going to, show me stuff I don't necessarily want to see. So things like that, they have certainly a little bit of a record for that argument that the world has changed, and therefore the rules, the principles, the philosophy of transparency needs to be reconsidered. They may or may not get any headway on that particular issue, but that's what I see them doing. Just because the law is so unfavorable to them in Utah, they're constitutionalizing it, trying to make sure that they consistently represent this as being an issue that is governed by standards the federal courts would consider. And so, yeah, that's just what I'm seeing here. This is part of the habeas strategy right off the bat, is trying to set up the opportunity for a Tyler Robinson, who is convicted in this situation 10 years down the road, being able to go to a federal court and say, hey, I had an unfair trial because all these cameras were in there, and they shouldn't have been, and we tried to keep them out. And here's why the law should find in my favor. And they'll just have a little bit more leeway to kind of argue the principles and the policy behind cameras in courtrooms that the Utah court is not going to be nearly as concerned with. So, conflating these standards, I don't know, is particularly helpful to them. But I guess it doesn't really matter if a lot of this is just kind of making the record and not a lot of high hopes that it's going to be granted anyway. I don't anticipate Judge Graf is going to grant this stay, but we'll get through this filing and then talk a little bit more about why. The United States Supreme Court granted a stay request in the case Hollingsworth versus Perry. In Hollingsworth, the court determined that an order permitting the broadcast of a federal trial should be stayed because the district court failed to follow the appropriate procedure to alter the rule prohibiting such broadcasting. The court emphasized that the harm from broadcasting could not be undone. Here's their quote. Applicants have also shown that irreparable harm will likely result from the denial of the stay. Without a stay, the district court will broadcast the trial. It would be difficult, if not impossible, to reverse the harm from those broadcasts. This court has recognized that witness testimony may be chilled if broadcast. Some of, all the way back to 1965, that's Estes versus Texas. This is the case that was extremely hostile to cameras. Basically said, like, having cameras in the courtroom is a due process violation. They said it was in this case, but then they came back in the late 70s or early 80s in Chandler versus Florida and said, we didn't mean that it always violates due process to have cameras in the courtroom. And in that particular case, cameras were fine. Cameras were fine. Some of applicants' witnesses have already said that they will not testify if the trial is broadcast, and they have substantiated their concerns by citing incidents of past harassment. These concerns are not diminished by the fact that some of applicants' witnesses are compensated expert witnesses. There are qualitative differences between making public appearances regarding an issue and having one's testimony broadcast throughout the country. Applicants may not be able to obtain adequate relief through an appeal. The trial will have already been broadcast. It is difficult to demonstrate or analyze whether a witness would have testified differently if his or her testimony had not been broadcast. And witnesses subject to harassment as a result of broadcast of their testimony might be less likely to cooperate in any future proceedings. So that's some pretty strong language given that context. Now, the language that they used is a little bit, I just notice a little bit of kind of legalese here that failed to follow the appropriate procedure to alter the rule prohibiting such broadcasts. So I'm just kind of reading between the lines here of what this case is about. If there is a rule prohibiting broadcasting, okay, rule prohibiting broadcasting, but the court changed it, and the court didn't follow the right process to change it, that is a very different context from where we are at right now, where there is a rule presumptively granting broadcasting unless certain showings and findings are made and so forth. So it's good language, but factually, I'm not sure that this case is really the same kind of legal context that we're dealing with in our situation. As in Hollingsworth, if proceedings continue with EMC coverage through the pendency of his petition, the prejudice to Mr. Robinson evidenced in his lengthy motion, reply, and witness materials will continue and will be compounded. As expert witness Dr. Christine Ruva testified, this case is already situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality. Now, this court is poised to add to the prejudicial publicity flowing from the courtroom with the impending preliminary hearing, where the state intends to proceed with a presentation almost exclusively comprised of reliable hearsay admissible for preliminary hearing purposes only through the testimony of law enforcement witnesses. Such evidence is, by definition, not admissible at trial. Now, that's not correct. That's not actually correct. Utah does define in this rule what reliable hearsay is, and one of the types of reliable hearsay is hearsay that would be admissible at trial under the hearsay exceptions and the non-hearsay use of out-of-court statements and things like that. So it is not by definition not admissible trial. Some of it very likely could be, but they seem to be anticipating probably some stuff that would not be admissible normally at trial, which is fair. At trial, law enforcement officers generally don't get to testify about, here's what this other cop told me about what he did for his investigation. You have to get that cop on the stand, and that's because you have greater confrontation rights at trial than you do in the preliminary hearing process. But now we're having like this layering, right? This layering of the issues, where things are kind of like intersecting. You know, we're trying to maybe a little bit muddy the water with the variety and relationship of our different complaints. So the cameras are bad. Part of the reason why the cameras are bad is because it's going to, you know, relate to this other complaint that we have about Utah law that says this is okay, and we don't think it should be. Utah law, again, very clearly and explicitly says this is okay. The Utah Supreme Court has said this is okay on this, again, like specific ground that the defense is arguing. They're just arguing that decision is wrong and should be changed. But that's not Judge Graf's pay grade. He is bound by that rule unless and until the Utah Supreme Court follows it. So Judge Graf is not going to say you can't use reliable hearsay because it violates his Sixth Amendment federal constitutional rights to confrontation, because the Utah Supreme Court has already said no, it doesn't, and he is bound to follow the decisions of the Utah Supreme Court. But they're going to layer this in. You know, we think this is a problem, so we're proceeding as if it is a problem, because should years down the road somebody once again in the federal courts decide this is a problem, then the greater implications it can have, then the bigger possibility that we're going to be able to point to some reason why it warrants a new trial. If it's just like an issue standing alone, it's one thing, but if it implicates all of these other problems, then it's a bigger deal. So I'm still seeing most of this through the framework of just preserving things for federal habeas corpus review in like a decade. But just kind of tricky how they're doing it. So such evidence is by definition not admissible at trial, and yet through EMC coverage of the preliminary hearing, the public, including potential jurors, will be flooded with evidence that cannot be used at trial, but almost assuredly will be relied upon by jurors, even if unconsciously. And this goes back to, once again, our basic debate. The defense is saying this is going to be an unavoidable problem. The judge is saying, no, we'll just bring in a whole bunch more jurors. So these people who paid attention and got themselves flooded with the evidence, we can just, sort them out. And we'll be left with the people who didn't really care at all, who don't follow this type of thing and, aren't interested, didn't register, and so forth. As explained by Dr. Ruva, so when a juror is exposed to pretrial publicity, they have two sources of information. They have the pretrial publicity that they get prior to trial, and then they have the trial evidence. They then have to differentiate between all of that information they got before trial from the evidence they got at trial. And this is a very difficult task. My research has found that jurors with a high amount of confidence believe that information was only presented in the pretrial publicity was presented at trial. They then use that information to make decisions about guilt unknowingly. And this was the source attribution problem. If you have a bunch of people on your jury that watched a whole bunch of the pretrial process and they learned things from that, they then sit through the trial and they watch all of the evidence at the trial, and then they go back into the jury room to start to talk about what they think and whether the elements have been proven. And so, well, what's the evidence? And it starts to get hard to distinguish, to remember clearly, this is something that I heard in this context at trial. Easy to conflate it or confuse it or something with something you heard in the pretrial process. Potentially a very real problem. Can't really agree with that or disagree with that. But also kind of hard to disagree with Judge Graf's point that it is potentially possible to just sort out people who know too much. And we're ultimately not really going to know that. I mean, we'll probably get another jury questionnaire, jury survey, like they did in the Koberger case for the motion to change venue. I would expect we're going to get something like that again. So might get a little bit more insight into the specific jury pool, Utah County, and here's what people have been exposed to and what they're thinking and stuff like that. But otherwise, yeah, we don't really know. Don't really know what the risk is of too many people showing up that know too much so that we can't sort them out and just be left with prospective jurors who don't actually didn't get exposed to any of this stuff. A stay should be granted to avoid adding to the creation of unconscious bias in potential jurors from EMC coverage of a preliminary hearing full of hearsay that will be repeated over and over in the coverage of this case. Finally, a stay should be granted because the procedural framework ordered by this court to challenge EMC requests, including with respect to the preliminary hearing, deprives Mr. Robinson of procedural due process. The court has afforded the parties 7 total pages of text with no argument whatsoever to raise practical and constitutional concerns specific to EMC of each hearing. Based upon the briefing schedule ordered, the parties will only learn of the court's order within 3 days of the applicable hearing, leaving no time for a party to seek further review. In this footnote, Mr. Robinson notes that it is unclear in the camera ruling if a motion challenging EMC need be filed even where EMC has not been requested to ensure a timely objection to an untimely EMC request. As currently written, the court may still consider an untimely EMC request, but Mr. Robinson may not be able to object if that request is filed less than 10 days before the hearing. That's the kind of thing that normally is very good for a motion to reconsider. If some aspect of the order is unclear about what does this mean, are there implications here that maybe you didn't think about that could be clarified, then you just bring that to the court's attention. Consider clarifying what you meant by, opportunity to respond and stuff. They didn't do that. And so instead are kind of, just they don't like the process, but they really didn't ask to change it. Procedural due process at a minimum requires adequate notice and a meaningful opportunity to be heard. That is very much the law, but it's hard for me to see how the order that Judge Graf entered doesn't give them that. I mean, he expanded the notice and process that they get under the Utah rules. So what I'm seeing in this is kind of some allegation, some assertion, like this is our position, this is how we feel about it, but I'm not seeing a lot of analysis about why. Like break this down. How is this a problem? Break down what exactly about this order is unfair to the defense. Like he did this to be extra fair, so I am quite sure the state will respond to that, but we'll see. The challenge order provides for neither and leaves Mr. Robinson without remedy. See, this is over. This is over the top. This is over the top. It absolutely provides for notice and an opportunity to be heard, far more than the existing procedure does. And so here's kind of the irony now of them relying on the Hollingsworth versus Perry, right? Hollingsworth versus Perry is like the mirror image of this case, where there's a rule that says you can't broadcast, you can't televise court proceedings. And the judge said, I'm going to do it anyway. And there's a process that I'm supposed to follow to allow that, but I'm not going to follow it. And so the court said that's an abuse of discretion. The rule is no cameras. You didn't follow the rule to allow cameras. And so that was a problem. We are in the like polar opposite situation here, where the rule is that cameras are allowed. And there's a process set up in the rule for how cameras are to be granted or not granted. You know, how the request is to be considered and the standards to apply and the findings that need to be made. And what kind of notice and opportunity to be heard is called for. And so Judge Graf modified that to give the defense more notice, more opportunity to be heard. There's no like process to do that he followed, right? There's nothing in the rule that says if you want to handle electronic media coverage differently, go ahead and do it. If you want to deny it, do it under this other process. But they're saying, I mean, what? Like, I don't know. I guess they're saying there's no process that allows him to give them more notice. It's strange to me. I'm having a hard time seeing how the defense is aggrieved by this ruling. Because if you take this ruling away, then the default position is like right up to the day before the hearing. Somebody can submit a request for electronic media coverage and the judge can just grant it. And that's kind of typically what has happened throughout the course of this case. There hasn't been, you know, opposition on a per hearing basis. So now he makes them file it much earlier so that the defense can say, we object, and here's why, and make their record. And the defense is complaining about that, as that's procedurally improper. This is not really adding up to me to a strong case for a problem that the Utah Supreme Court is going to intervene with. Considering the consequences of proceeding with the preliminary hearing prior to appellate review and the procedural due process concerns raised by the current order, a stay of the case pending the Utah Supreme Court's review of the petition and the weighty constitutional concerns raised therein is both reasonable and appropriate. So the court should grant a stay of all proceedings pending the outcome of his petition. So that's why they want the preliminary hearing to be held up. So I do want to show you guys Exhibit A. This is not otherwise on the docket, but this is the petition that they have filed to the Utah Supreme Court, the request that they are making for this interlocutory review. It is, as you can see, well put together and substantial. So I am not going to go through all of this right now, but I just wanted to bring it to your attention that it is there as an exhibit to this motion to stay. So if you are interested in it, you can go find that in the archive, and it's the newest thing available. And you can look through their petition for interlocutory review. Actually, you know what? I take it back, because I do want to just see what the standard is so that we know. We spent a lot of times on the fact Okay. These are the standards of review. And it looks like they are not going to say real specifically the standard for granting interlocutory review. And that's not real surprising to me because it's generally not a particularly favorable standard. Well, anyway, that is available for you to go through. But we don't know now kind of what our status is on this. They've requested the stay. The hearing is scheduled to start in 5 weeks. We don't have a hearing on this motion pending. We don't have an opposition. It's just kind of there. We don't really know how this is going to be handled. So it will be a little bit of a wait and see. I am guessing that on June 12th, it's going to come up. Not that it's going to be argued, but whether they're just going to like decide this the day of the preliminary hearing or whether they're going to set up another hearing sometime between June 12th and July 6th to decide this. That seems likely to me, just for purposes of everybody kind of having notice of what's going to happen on the 6th. So you're not flying people in to testify and stuff like that unnecessarily. But we'll just kind of have to see how that unfolds. So that was the new thing that got filed today that I wanted to share with you guys and yeah, some of my thoughts about it, about interlocutory review in general. It's not likely to get granted. Because it's not likely to get granted, it's also not likely that the judge is going to put the brakes on the whole process and say, wait, so that the Supreme Court can, duly deny review. And then we can go forward with the preliminary hearing. If there was a really high chance that interlocutory review would be granted, then I think there would be a much higher chance that the stay would be granted. But I don't think it is. And a big part of the reason I don't think it is because most of this maneuvering, again, seems to me to be positioning for federal habeas review, not raising issues because we think that either this court or the Utah Supreme Court is going to be on our side. We think a future federal court might potentially be able to be on our side. And if not, we've at least, seeded the field for the future habeas counsel to have some things to be able to come in and work with. And because these are capital lawyers and they're thinking on the capital case time horizon, we're talking decades. And so one of the things that's always lurking is the possibility that the law can change in the meantime. Technology can change, society can change. This is particularly important in the Eighth Amendment context. Eighth Amendment is what prohibits cruel and unusual punishment. Back in the day, forget when Furman versus Georgia was decided, but back in the 1970s, when the U.S. Supreme Court decided the capital punishment period is unconstitutional. They banned capital punishment, but then turned around and brought it back. Eighth Amendment was the basis why. And the Eighth Amendment's prohibition against cruel and unusual punishment, the court has said this standard is it's based on what they refer to as evolving standards of decency. And so it's not a fixed thing. It's not like, just because drawing and quartering people was one time totally okay back in like the 1500s, that doesn't make it cruel and unusual. It's basically saying that as society evolves and progresses or whatever, our perspectives may change. And the perspective on what is cruel, what is inappropriate, what's fair treatment for people and what isn't, needs to be kind of incorporated into our standard of what we allow in terms of criminal punishment. So those standards can change. If we're looking down the road, going by the time horizon of Utah capital cases generally, remember Archuleta, he's been on death row for 35 years, 36 years, 34, something like that. Many, many decades. And so that is a lot of time for the the legal and the social context to change to something that might potentially be more favorable. So it's just a big part of what these lawyers are doing is looking down the road for things that we might be able to develop in a different context, in a more favorable context. 10 years down the road, the court's going to have, like courts all over the country and at different levels, are going to have had a lot more opportunity to grapple with, the role of social media and, the rise of true crime and stuff like that. And evaluate if that undermines the reasoning that led to these decisions that basically at this point very strongly favor public access to the process and to the things, documents and evidence and so forth that the judge relied on or the jury relied on to make their decisions in the case. So let's see what you guys have had to say. To Truth for Liberty question: can the parties stipulate to potentially violating the 1A by closing exhibits without also that stipulation facing the 1A scrutiny standard on behalf of the public? Yeah, I mean, they can stipulate that the way that it would work is just they would stipulate that it's not a violation of the First Amendment. And I mean, I feel like that's kind of where we're at. It's kind of what happened. Parties are all saying we agree there's no issue over access to the exhibits. So it's fine to prohibit access to the exhibits. The media is supposed to be the representative of the public in this. I don't feel represented by the media's position on this personally. But who am I? What's my standing, to come in and get involved in any of this? Pretty unclear. And so this is kind of the issue of it's difficult to have a right without a remedy. Okay, we the public have these First Amendment rights, but how do we go about enforcing them? It's not clear to me that we really would have a very good mechanism. I mean, not impossible, but just, somebody basically would have to go to court, challenge it, find a procedural pathway in, find a standing pathway in, and get the judge to disagree, with the stipulation, present your position that it is a violation of the First Amendment to seal off the exhibits. You're in a challenging position legally with that because of Nixon versus Warner Communications. This is the U.S. Supreme Court. That's kind of the sort of the landmark case for this principle that closing off court exhibits is kind of okay. And there's a lot of nuance to the decision that I think it has gotten overlooked or just not really taken as an important part of the rationale for the decision. In the subsequent case law that's developed, they just kind of overlook that part and they're like, well, Nixon says the court has discretion to kind of decide, manage the exhibits and stuff like that, and so we're going to just kind of let them make those decisions about access. So there's not necessarily great case law for a challenger on the First Amendment side when it comes to the exhibits, other than, you can certainly make it, but just you're on the back foot because of that Nixon case. You're arguing the nuance. Here's why Nixon's facts were different, and that's why the outcome was appropriate in Nixon. But it should not stand for this broad proposition that access to exhibits is just something that the court can kind of like willy-nilly do away with because of what's been a lot of subsequent case law dealing with both the First Amendment, but also a common law right of access to judicial records. So it gets a bit convoluted legally, but procedurally speaking, the question is just how do you enforce it? How do you get into the courthouse door if everybody who has standing that the court has recognized as appropriate parties to have input on this issue and they're not advocating our position, what's our avenue? It's not necessarily clear to me that there is one, but it's possible, I suppose. So yeah, practically speaking, they kind of can. They kind of can. Andrew Matthews, 1916. If a doctor removes bullet fragments while trying to save a patient, do hospitals have to give them to the police? Yeah, they typically will. In fact, it's very common for police to be present in the in the operating area, if not like actually in the room, but at least in the area for this purpose of recovering stuff that they obtained during treatment. His clothes are going to be cut off. They're going to get his clothes. In anything like this, bullet fragments, stuff like that, that they recover, they will take that into evidence. They will often get blood samples and things like that. DNA, their own DNA sample. So do hospitals have to give them to police? I don't know that there's a law anywhere that says specifically they have to do that, but it just is routinely done. In this particular case now, we, at least the way that it's been presented, is that the bullet fragments were removed during the autopsy. Not while he was being treated by surgeons in the hospital, but while he was being autopsied by the medical examiner. And that comes from just one of the filings that the state had made about this whole issue with the ATF report and the testing that they want to do and so forth. So the state had referenced the bullet fragments recovered during the autopsy. So I'm not sure that that's going to be an issue in this particular case, but in general, that is the way that things often go. Ginger Puff 764. Hi, Andrea. What about the issue of the victim advocate's right to a speedy trial? Doesn't that factor in given how long all of this is taking? Yeah, it's definitely going to be part of the consideration with this motion to stay, because it will, cause further delay. And so there needs to be a good reason for it under the victims' rights rules. One of the things I found kind of interesting about Utah's victims' rights law is just the way that it's written. It says that basically, I'm paraphrasing here, but it says basically that the victim's right to a speedy trial should be considered under the same standards that apply to the defendant's right. So basically, like, they have the same right vis-a-vis the speedy trial. So when a defendant is arguing something's violated my right to a speedy trial, there are specific factors that the court looks at to evaluate if there is a violation here, and these are called the Barker v. Wingo factors, based on yet again an old U.S. Supreme Court case, Barker versus Wingo. And it's these four factors that are essentially looking at what's the reason for the delay and who caused it, and how bothered was the defendant by it, basically. And so, at least in theory, to me, it seems like if the Utah law is that the victim has the same right as the defendant vis-a-vis the speedy trial, then the victim can potentially invoke these Barker v. Wingo factors as well. Or it just seems like, maybe we would be considering these factors kind of with respect to each side, to the defendant, but also to the victim, what sort of prejudice and things like that. Haven't seen that actually play out, explicitly in any of the court filings or the way that the courts evaluated these issues, its rulings or anything like that. But just from a logical standpoint, it makes sense to me that that's kind of what the legal framework is. So yeah, if he's looking at a potential delay and is it justified or not, he absolutely, under the rules that they operate under in Utah, has to consider the fact that Erica wants a speedy trial and she has the right to demand one under Utah law. So it is another factor for why I think the stay is unlikely. Not likely to get this relief from the Utah Supreme Court anyway. Also not clear to me, Utah Supreme Court could potentially stay it as well, possibly. haven't gone in and looked up the procedure, but it would be kind of uncommon, I guess, if they didn't have the authority to do that. The trial court can stay itself. That's one option, but it's also possible the Supreme Court can say, you lower court need to put the brakes on things and hold up your process while we decide this important issue. So they're not necessarily like out of luck if Judge Graf denies this motion anyway. It's just that, if the whole thing is kind of stacked against you in terms of this going anywhere, then you're not likely to do any better getting the Utah Supreme Court to stay it than the trial court. But yeah, absolutely good point. The victim's rights to a fair trial are going to have to be considered as part of this as well. Kang the Conqueror 2025. Can we just have the trial already? We literally had a hearing weeks ago for the judge to decide if we are going to have another hearing. Thanks for your commentary, Andrea. Welcome to court. Welcome to court. I mean, this is what it is. This is what it's about. Hearings about hearings and hearings about process and all of that kind of thing. This trial isn't going to happen anytime soon, guys. It's not going to happen anytime soon. It's going to be years. Early 2028 is still 2 years down the road. That was my kind of over under initial estimate. I got to tell you guys, I feel like even that is a little bit accelerated by death penalty case standards. But kind of cutting on the other side of that is, referring back to the previous comment, this kind of unique situation in Utah. I mean, not super unique, but somewhat unique in that the victim has rights to the speedy trial as well. So it just means that, the defense is going to have to justify, the state would have to as well if they want to continue it, but they're going to have to justify that based on investigative needs, preparation needs, things like that. Are they going to be able to justify more than 2 years worth of potential delays to the trial? Frankly, it wouldn't surprise me, just given, again, what we kind of already know, that they're teeing up to litigate in the case. And they're in the position where they kind of have to. We know from the evidence list and just everything we already know about the case, we know kind of what the many, many layers, the corroborating layers, are the problem for the defense here, because you have DNA that is corroborated by statements, that is corroborated by video, that is, corroborated by ballistics, at least, so far as we have been led to believe from the filings and the lack of contradiction of that so far from the defense. And so this is a problem in terms of presenting a factual defense, because talked about this before. Okay, let's say I can get the DNA thrown out. I can get the DNA thrown out. Is that going to fatally damage the case when they still have video and they're still going to, have location data, which we don't know about yet, but we know that they're going to have access to, they're going to be able to get that. Let's just assume, for the sake of argument, that is, again, corroborating. Tyler Robinson went to UVU the morning of September the 10th, his movements and so forth. That corroborated with, I don't know, surely somebody's going to identify this gun. Somebody can identify the gun, or they got the, serial number for the gun. Maybe there's records. Don't know about that, but corroborated by, his statements and stuff like that. Is it going to fatally undermine the case if they don't have the, actual DNA of his finger is on the trigger? If they can otherwise show that it's his gun and he had it and he went to UVU, it's not going to be a problem. So this is why the defense has such a challenging task in a case like this, because you can't just toss out the DNA. You have to toss out the DNA, and you have to toss out the video, and you have to toss out the confessions, and that's your only real chance at having a factual defense. So that's what they are going to do. That's what they're going to try to do anyway. We already know they're going to try to throw out the DNA on the technological grounds. We already know they want to try to limit, I keep saying ballistics. It's really not ballistic stuff. It's the tool mark comparison. But, connections between the bullet fragments and the firearm, connections between the cartridges that they found, and the engravings at Tyler Robinson's house versus the ones that were recovered with the firearm. Try to limit or exclude that. Statements, always, they're always going to be looking at, are there Miranda issues with this? Are there voluntariness issues with this? Like ways to try to get the statements out because, statements are particularly bad evidence, even though talked many times, so many cases about, confessions, not always really very good evidence. And, a lot of times they are, but many reasons why people falsely confess to crimes. Can't really rule that out, just per se. But people are heavily influenced by confessions or self-incriminating statements and stuff like that, because people just assume I would, if I was innocent, I would say I was innocent. I would never say I did something I didn't do. It's hard for people to relate to why somebody would say things that aren't true. So, going to be trying really, really hard to get those kinds of things out. All of this is saying that we can anticipate an awful lot of litigation leading up to trial in this case. And a lot of it is going to be, particularly the scientific stuff, it's going to be very technical evidence. It's going to be expert heavy. It's going to require a lot of review. Working with experts in general, a little bit of a nightmare just in terms of the time management, because everybody's busy and nothing is, an emergency. Not real uncommon, I think, to have a DNA expert, get a DNA expert on board in your case, get all the stuff for them, send them all the materials, and 6 months down the road, maybe you don't even still have an opinion yet. There's a process of, no, we need additional things. So then you have to go back and you have to find it. You have to, find a discovery mechanism to be able to obtain whatever it is that they need, get it to them, coordinate all kinds of stuff. This stuff is time consuming. And there's potentially a lot of it on the table. So trial is not going to happen anytime soon. And there is going to be a lot of litigation that happens before we get to that point. To Truth for Liberty, can an individual member of the public file a motion to substitute the public representative for cause? I don't know. So there does not seem to be, I'll just put it this way. There does not seem to be anything in the Utah procedure that contemplates just any random member of the public having standing to assert a right to be heard on these types of issues. They do it, provide for the media, but not necessarily for the public. Now, would you be able to figure out a way and an argument to get there? Potentially. Once again, if you look into the world of the case law, when it comes to public access to court proceedings and documents and things like that, there is some pretty good language in a lot of this case law that there needs to be, an opportunity for the public to be heard on it. And so it's common in some jurisdictions and in some cases and stuff, where if we're going to, for example, close the preliminary hearing, we need to have a public hearing on whether we're going to close the preliminary hearing. And the reason why is because the public has the right to be heard. And so people would, at least in theory, have the right to sit there in court and, raise their hand at the appropriate time and say, Judge, I want to be heard. And here's why I think that the preliminary hearing should be open. This is the theory of it. The practical reality is that rarely happens. And even though even though there's like language favoring giving the public an opportunity to have input on these types of decisions, practically speaking, judges tend to be resistant to that. They don't want to hear from the audience. It's not normal. It's like kind of one of your hardline rules about court procedure is you people on this side of the bar get to address the court, and the rest of you out there in the gallery, you are observers. And so it's like a hard defining line. They don't like to muddy it by saying, oh, sure, anybody from the audience can like come forward and speak. Limited circumstances when they do that, when they invite, feedback like that. So for things like, at sentencing, when they have victim impact statements and things like that, very clear, that happens. But outside of that, you'd probably have to be like convincing the judge of why you have the right to speak in the first place. And when your basis for that is, federal case law that just kind of says, you have a right and opportunity to be heard. I don't know. It's just easier for that to be kind of dismissed or just procedurally avoided, I guess. So, it's a big I don't know. I mean, substitute the public representative? No, they can't get rid of the media's lawyer. The media is entitled to their own lawyer, and they get to choose who their lawyer is and stuff like that. But it's something more along the lines of, I want to have my own voice heard because the media isn't representing me as a member of the public. Could you do that? Maybe. In a case like this, I maybe, wouldn't recommend it, if only because we already know the case is being positioned for future federal courts to look very closely at the implications of media and commentary and publicity and people knowing about the evidence in the case and stuff like that. And so adding to the record of, this is just a circus, so to speak, a media circus, just far too much public interest. It would be kind of emphasizing that point that like maybe this case is a little bit unusual or getting attention in ways that maybe it shouldn't have. So I don't know how much, just from a standpoint of interjecting in the process, is a particularly good idea, but that's, it's always a judgment call. And that's, I guess, the difficulty you face when making the decision about whether you're going to try to intervene and assert public rights or something like that. There's always trade-offs to pretty much any decision that gets made. But this particular case, that would just add to the record in many respects of there's like unusual public interest and too much attention to the details and stuff like that. But that is, of course, just my opinion. So, guys, coming back on June 12th. So we'll get this order to show cause hearing first. We'll do the evidentiary hearing. My chat is still dissing on my Mr. Slovak. Yeah, if he handles the OSC questioning, and it could be a long morning. It could take a while. We'll just we'll all go ahead and acknowledge that. Maybe he won't handle it. But it is looking like the June 12th hearing is going to be a little bit, certainly more extended than we had today, but potentially a little bit more involved. Something like, testimony taken in the morning session. They break their lunch, come back in and argue. He set aside 3 hours for evidence alone. Don't know if they're going to use that full amount. So we'll see. And then come back for the argument for the motion regarding hearsay. So this motion I have not I mean, I haven't talked about it in depth. I haven't really covered it in depth. And the main reason why is because to me, it is clear that this is a pro forma motion. It is not going to win. It is certainly not going to win in front of Judge Graf. It's yet another thing where they're preserving the record so that they can ask the appellate court, and it will likely not be the Utah Supreme Court. They will ask the Utah Supreme Court to reverse itself in its previous decision where it said this doesn't violate the Sixth Amendment, but ultimately that's not likely to happen either. And so this is really about getting it up into a federal court to say, does this Utah process violate the Sixth Amendment of using this hearsay in preliminary hearings? The state, it's been briefed. I mean, in the sense that they have defense filed their motion, the states filed their opposition, and those things are available on the archive as well. You can take a look at those if you're interested. But I will say the state's response to me is indicative of this. We're all recognizing that this is pro forma. They call out the same thing I did, which is that the Utah Supreme Court has already explicitly decided this issue. Judge Graf is bound by that decision, so he's going to have to decide it against the defense's position. And then, yes, maybe someday it will go up, and somebody will have a different opinion about it. But it's pretty much a foregone conclusion where we're ending up on this one, because there is controlling case law that is directly on point that he has to follow. So they will argue that. They're making their record, so I don't expect them to necessarily be terse about it. They will want to say everything that they feel needs to be said on that particular subject. But it's probably not really the priority either, because this is making a record. So I expect, pretty good morning, extended morning as far as taking the evidence on the order to show cause, and then probably a little bit less in terms of argument on the motion regarding whether the reliable hearsay should be allowed at the preliminary hearing. End of the day, I think it's going to be really no matter what, and this will be an issue for a higher court to take a look at someday down the road. Under all of the permutations and ways the case could go that ultimately get us there. But bottom line is just, we're anticipating if Tyler loses at trial, or just doesn't plead and has some basis to appeal, that these issues are going to be available to him, the kinds of things that he's going to pursue to try to get a new trial. So, we'll be back. We'll be back to watch that. I will certainly be here to watch that on the 12th and see how that goes as we inch closer and closer to the preliminary hearing. And probably we'll find out, like I said, on the 12th, what's going to happen with this motion to stay. It's up in the air. All I can say is we'll see. I'm not particularly concerned about the judge delaying it again, but we will see. Pooping while standing. Hey, that's a skill. Welcome. Andrew Branca brought me here. Look forward to more. He's really been killing it with this whole what's now, I already forgot the guy's name, the Chud the Builder. The Chud the Builder case. Yeah, anytime there's an interesting self-defense case or argument out there, Mr. Branca is the one to look to for the law on that for sure. So welcome. Glad you made it over. I guess that's about all we have for today, guys, until we get back on the 12th. I don't think there's a whole lot else to go through. I'm trying to think if there was anything else new on the docket. Not really. And check my archive real quick. It looks like, I did not somehow get the motion, the state's opposition on the hearsay. They have filed their response, but I did not get that uploaded onto my archive. So I will do that now while I speak, so I can say that it's done. And then when I tell you to go find it there, I'm not lying. It is in fact there. It's document number 557 for those of you who care about that type of thing. All right, so it is now updated and available. We'll be back on the 12th for this hearing. For those of you who are interested in Mickey Stines, it's been like a million years since we had Mickey Stines in court. Had to get through that whole situation with the judge. He was trying to disqualify the judge in his case, but that has now been resolved. And so we are back in court in Mickey Stines' case on Friday. It's going to be a little bit earlier for me. If I remember, it's going to be one of those, it's like 10 o'clock their time, which is going to be 7 o'clock my time, which means I'm going to get started at like 6:45. Oh, the old East time trials, man, over here on the West Coast is it's a vibe. It's a way to live, I guess. So it'll be an early start, but I don't want to miss it because it's the first thing that's really happened in the case, like I said, in quite a long time. And it also does look like the judge is kind of wanting to accelerate progress in the case. There have been some things that have been waiting to be resolved while this judge issue was kind of circulating the different levels of the courts that looked at it. So they have the state is trying to change venue in that particular case, which is interesting and fascinating to me because it's quite unusual for the state to be the proponent of a motion to change venue. Normally it's the defense, and often in lots of cases, it's not even an option for the state to ask for a venue to be changed because many state constitutions have what's called a vicinage clause, some type of requirement that the trial take place in or that the jury be drawn from the county, the locality where the crime occurred. And so if the defendant has a right to that, then it's the defendant that has to waive it to ask to be taken to another venue. But Kentucky doesn't have that. Kentucky lets either side make an argument that you can't get a fair trial in this particular venue, and so it needs to be changed. So the state has asked for a change of venue, and I find it fascinating. We know, obviously, Mickey Stines, he was the sheriff. He was elected. He is quite popular. He continues to have support from his former colleagues and other people in the sheriff's office. And so clearly looks like the state thinks this is maybe a little too favorable for him in this jurisdiction. Might get a jury pool that is a little too willing to give Sheriff Mickey Stines the benefit of the doubt. So I'll be interested to see that argument and how that goes. Then the other thing that is outstanding is he had requested that bond be set. And so there has not been a bond in the case so far because it is, at least it's a capital case. It qualifies for the death penalty. There hasn't been any, movement towards them seeking death or anything like that. No indication at this point that that is going to happen. But nevertheless, it's death eligible, so it's a capital case. And so there is a presumption against bond being set, except in like certain circumstances. And so he's basically arguing that under these circumstances, he's got evidence, pretty good evidence of a defense, or at least like a partial defense that's a little bit unique to Kentucky law, where you can say I did something, but I'm mentally ill, like I'm guilty but mentally ill. It's a little bit unusual because normally when you get into like mental illness or psychiatric defenses or things like that, you're looking at situations where you're going to be hospitalized instead of going to prison, because you're insane at the time of the crime, you need treatment or something like that. And so Kentucky has that, but then they also have this guilty but mentally ill type of outcome where it's sort of like mitigation, like it's not enough to make you not criminally liable, but you get apparently mental health treatment in prison instead of, I don't know, not getting mental health treatment in prison. Anyway, he seems to think, and has argued, and the record seems to suggest it's not a zero possibility outcome that he could get something like this serious, guilty but mentally ill type of outcome. And so that's one of the, like, kind of generally speaking, this is one of the exceptions under Kentucky law for when they should set bail in a capital case. So he's arguing, I've got a credible defense supported by evidence, and I'm very interested in hearing more about this, assuming that is, where he's going and his basis for bond, because what we know about the mental health defenses so far is strange, conflicting. I don't know. It looks weird. He was claiming to have California encephalitis in the days before this murder took place, the shooting took place. But he is describing symptoms and kind of a disease history that is really not how California encephalitis works. He's not really in an area where you tend to get California encephalitis, and California encephalitis in general is extraordinarily rare. It's an extremely rare disease, almost exclusively affects children. And so it seems highly improbable, right, as an explanation for what Mickey Stines did. And I mean, he's on camera doing it, no question, really no dispute in the case that he did it. The whole issue with the defense is why. But there was a psychological exam, an independent psychological exam done at the state hospital that seems to have been favorable to Mickey because he wanted it to be public. He wanted to be able to, like, talk about it at this bond hearing and rely on it and stuff. Those reports are confidential as a matter of statute in Kentucky, so that was denied. But seems that he got the state psychologists to favor at least some kind of mental health defense. And so, what is it and how does all this play together? And, like, how does the California encephalitis fit into all of this? I'm very intrigued by this, because my initial reaction to the whole California encephalitis thing is like, that is the strangest malingering I've ever heard of. Like, it just seems so improbable that it seems likely it's made up, right? It's made up. But at the same time, how do you make up something like that? How do you pick that? Why would you even pick that? Like, why would you pick the rare disease that doesn't present like this, that only children get, as your cover, I guess, is what it would be in that situation. And is Mickey Stines, I'm just going to kind of say it how I see it. He hasn't really struck me as, like, the most intellectually sophisticated defendant. Is this guy really going to be, like, smart enough to come up with that and then play it off somehow? I don't know. It's very strange. So I'm quite curious to see how all that plays out, and it seems likely that we will get some more information about it on Friday, because we'll be hearing his request for bond, and so he'll need to talk about his defense. At least I'm anticipating he'll need to talk about his defense and the basis for it, and why it means that he's got, a pretty non-zero chance of maybe beating the capital murder charge that he's currently facing, or at least, getting the mentally ill type of defense. So yeah, I'll be watching that bright and early Friday morning. You guys are welcome to join me for that if you are interested. Should be entertaining, should be interesting for sure. Yeah. California encephalitis is a viral infection of the brain transmitted by the bite of affected Aedes mosquitoes. It does tend to be a West Coast disease, hence why it is called California encephalitis. But it is not exclusively, like, it's theoretically, yeah, you could maybe get it from a mosquito in Kentucky. It's just that it usually presents as more of a acute, like, inflammation that then resolves. And the way that Mickey Stines has kind of described it is much more of a chronic condition. He's described it a little bit more like people describe chronic Lyme disease, which is not real clear if that's actually a thing or not either. But yeah, he's described, like, for years having these episodes of confusion and bad memory and stuff like that. And this came up in his deposition because his lawyer was using it as an excuse for him not remembering, various questions that are asked of him. He doesn't remember, and these episodes from California encephalitis that he regularly suffered was the reason for that. It's just that that's not usually how California encephalitis works. So it's a little bit weird. Miss Riss XOXO, when will facts finally end Charlie Kirk conspiracies? Miss Riss XOXO. Let me be the first to unfortunately bring you down to earth, which is that facts are never going to end conspiracies. Conspiracy and fact are polar opposites. Conspiracies are resistant to fact. Conspiracies are in denial of fact. Like, this is kind of what makes them conspiracies. It's never going to end. There will always, it doesn't matter how strong the case is, how strong the evidence is, how well it's tied up. There are always going to be people who don't believe it for whatever reason, who say it's all fake for whatever reason, or just maybe none at all, just, oh, it's fake. It's fake. That's not going to change. There is really no volume of fact, no volume of evidence that could ever change that particular tendency. And I mean, I guess that's okay. It's just sort of how the world works and how people are. The question is really the reach of the conspiracies and how many people are going to believe them. And I think the issue here is just that as more and more of the evidence becomes public, the people who are not fact resistant, or evidence resistant, or there's a lot of, like, there's a lot of, defense lawyer strategering that's happening in conspiracy land, like all these kind of expectations about what the defense is and what the evidence would be and what can be proven and what can't and stuff like that. And so as the process plays itself out, and we see the defense team engaging in the strategies and raising things or not raising things as the evidence supports it, some people are going to be, persuaded by facts, persuaded by evidence. Oh, I had questions, but this evidence actually does resolve it for me, and it makes sense, and I'm satisfied with the explanation, and I don't buy the conspiracy anymore. But there's going to be plenty of other people who will, and who will just be like, oh no, the defense lawyers are part of the conspiracy, so if they didn't argue that, like, the Discord messages are forged, it's because of the defense and not because of the evidence. That's always going to be there. So I hate to spring that on you, but the conspiracies are unfortunately likely here to stay. But nevertheless, the case does march on, and I suppose one of the things I've thought about, I know I've mentioned it in private, don't know if I've talked about it on the stream before, but any kind of high profile case that has a bit of vulturing around it, they're going to stop picking the bones once the bones are clean. And the thing is that the interesting part of this case for the overwhelming majority of people is the trial. It's the trial and the that type of display. And so that's kind of the peak of where the interest is going to be. But the case itself, like, so that's where kind of likely the bones are going to get picked dry, because once the trial is over, there's no longer anything really exciting on the horizon for people to watch. There's no big exhibition and display of evidence and people testifying and stuff like that. That part of the case is basically over. But as we've seen and talked about, like with Archuleta, these cases actually last decades. And so the vultures will be gone when the bones are clean, but the case will be going on for quite a lot longer than that. And so it's going to be kind of obvious. It's going to be kind of obvious who is interested in justice for Charlie Kirk and who is interested in picking the bones. And you're going to see that based on who sticks around once the bones have been picked clean. Once there's no longer, a trial that everybody wants to watch, that's going to get people, all the views and everything. And it's just boring legal maneuvering, the stuff that brings families back to court over and over and over again, sometimes for decades, after their loved one has been murdered or, otherwise abused and victimized. They will still be living with this case. The people who loved and cared about Charlie will be living with this case long after the jury decides whatever the jury is going to decide. And so, court is a long game. Court is a long game. It does require a lot of patience. But some of these things will kind of sort themselves out with time. I mean, if there's one thing that we can be confident in, possibly the only thing in the entire universe that we can be confident in, is that with time, the situation will change. It will be different if we wait. It's not always easy to live with that, but that is just where things are. Miss Ricks XOXO, when will Candace no longer be able to grift? Miss Ricks, grifter is going to grift. Grifter is going to grift. If people want to grift, they will find ways to grift and things to grift off of. It's just the nature of the game, I suppose. And so, the grift lasts as long as the audience interest does. That's why I think, at least in that sense, the trial is, kind of a pretty predictable, end game for the grift, because there's not going to be anything to grift on after that. How many people are going to grift on appellate briefs? Okay. Few of us. I will love the appellate briefs. I will be there. I will be there taking copious notes. LawTube will love the process, but the excitement part is gone, and so that's likely going to take the grift with it. So, yeah, why not end the stream today with a little controversy, right? I'm not, I don't follow the chat. I can't read the chat and talk at the same time, but I can already envision, you're a grifter too, whatever. Raguso, odds of an eventual plea. I've said before, in my mind, it comes down 100% to whether the county is going to offer to take the death penalty off the table. Seems to me that they are not likely to do that. If they were inclined to do that, they probably would have already been receptive to it. If they were already receptive to it, I think that just comes down to, do you think he would have taken it or not? And that depends on what's your view of the evidence that they have so far, the likelihood that the defense will be able to undermine it, either by, presenting problems with it or by getting it excluded for any variety of legal reasons. I've said before, to me as the defense attorney, looking at the probable cause, everything that we've learned about the evidence that they have. This is not an easy case. It's the type of thing where if he didn't actually do it, then there should be a thing that can help you establish that. There will be ways in which the evidence will not converge on Tyler Robinson, driving to Provo, driving to Orem, getting on the roof of the building and stuff like that. So good example would be the location data. We don't know anything about it so far other than the fact that they had it. But if Tyler Robinson didn't do it, then I would expect his, phone location data would put him somewhere else. And if the phone location data puts him somewhere else, that's extremely strong evidence for the defense. Still got some other stuff to explain, but, gives you something really factually strong to work with. But if it doesn't, and it puts you there, then you're in a tough boat. You're in a tough boat. And again, the reason why is because, okay, we can point at all kinds of questions that people have, or, the thing that is sort of the constant theme, the 30-06 bullet that didn't exit, no way, a lot of skepticism about it being a 30-06. I've said before, I'm expecting plenty of explanation of that from the medical examiner, but we'll see, of course, how that goes. But in general, not really that common for high velocity rifle ammunition to not exit to such an extent that it is recognizable. It's like recognizable patterns on X-rays and stuff like that for forensic pathologists, also like wildlife pathologists and stuff that look at this type of thing. But correct, it doesn't happen every time. It's not like the probable outcome. It's not like 51% of the time the bullet's going to be retained. No, it's probably lower probability than that. 1 in 10, 1 in 20, maybe even 1 in 100. It might be rare, but that doesn't mean it didn't happen. So I understand a lot of skepticism about the 30-06. Maybe we'll get an explanation for it, but let's say we don't. We get no explanation. We still have this doubt that a 30-06 did this. Okay, understandable, but there's still a lot that has to be explained in terms of the rest of the evidence to provide an alternative explanation to what happened. Right? I continue to not really hear anything beyond like nebulous, well, they did it, they're covering up Fed slop. I talked about all this last time. It doesn't really mean anything. It's not anything specific. And so you still have to explain, okay, so then what are 30-06 bullet fragments doing in Charlie's neck? Okay, when he's dead. Where did those come from? What is Tyler Robinson doing on the roof? Why did he go to Orem? Why is he saying he did it? Why did he surrender himself? How is all of this a coincidence when actually somebody else, I guess, took the shot? Who did, from where, how, with what, under what circumstances? How is Tyler Robinson in this position of looking an awful lot like the shooter, but not apparently actually being the shooter? This is challenging to explain. And again, even, in the broader conspiracy land, to the extent I kind of can't avoid coming across some of these theories, still haven't come across an actual like material theory of this is how it happened. It's all very just nebulous, or this couldn't have worked or something like that. So that's the challenge I think that the defense team has. There is a lot of layers of corroboration. If there is something good and solid factually that they had to run with, they can. But I also expect we would hear about that sooner rather than later. We would hear about it in the court filings. We would see it like we did with Koberger, where, the public opinion is so strong against your client. Okay, everybody has already decided he's super guilty. He's like this weird, creepy incel guy. And there's been all these stories in the news about the weird stuff that he does and how people don't like him and people are afraid of him in bars and things like that. And so when you get stuff that's favorable to your position, like it kind of really looks like maybe he didn't do it because guess what? All of this follow-up investigation didn't find any connection. They looked through every single device he had. They never found any kind of connection between him and any of the victims. They never found any like blood or DNA transfer. This bloody crime scene, and none of it got into his car. None of it got into his apartment, nothing like that. Definitive, no, but helpful to the defense, very much, very helpful facts to the defense. And so what did they do when those facts became clear? They put them in a court filing so that the world would know, hey, let's try to even the playing field a little bit here in terms of what the public, the potential jury pool's expectations are when they come in for the jury service. Right? Let them think there's maybe some questions here. If we never tell them that and all they have is the state's theory, then we're not going to be surprised that they come in assuming that the state's theory is right. They've never heard anything otherwise. So it's like, this is so common sense to me. You would bring it up. You would mention it. And we've seen Tyler Robinson's team himself do that. Okay. We saw that during the contempt hearing when Kathy Nestor thought the thing, to drop was the DNA mixture. We didn't know that. It's helpful to the defense. It is helpful to the defense that the DNA recovered at the scene is a mixture of no less than 5 people. That is helpful to the defense because that is a complex DNA mixture. It means that might not be a good identification. Is that going to be enough to throw out the entire case? Probably not with all of the other evidence. But so they know how to do that. Okay. I don't know that they necessarily picked the one that like resonates with the public. The problem, I think, with the way it was presented was that like, okay, it's a 5-person or more mix. Like the public at large is not familiar with the ins and outs of the techniques of DNA analysis and the problems with probabilistic genotyping. Okay. I think in general, like trying to put on my hat as a layperson, what that sounds like is, well, okay, but his DNA was still there, right? Fine. There were 5 other people there, but his was still there. So how is that a problem? The lawyer in me that heard what she said recognized immediately, like, no, it's more than that because it implicates this technology and the ability to make this scientific claim. And so they're going to litigate that in court and so forth. But that's something I know because I wear a lawyer hat. I don't think that that's really how it lands with the public. You guys chat can correct me if I'm wrong, but it sounds like that whole it's a mixture isn't really, it just kind of sounds like, well, his DNA was there with other people. So it doesn't mean he wasn't there. Anyway, just pointing out that they know how to do this. They know how to raise things that they think are favorable to the defense, that they think could change the narrative. Oh, the ATF report was inconclusive. You put that in your file. We might call their people as exculpatory. You put the things in your filings. And so, yes, if there is location data that doesn't match, if there are timelines that don't add up, if there are absolutely a gazillion %, okay, confessions that are being fabricated and attributed to him and being proffered as evidence in the preliminary hearing, yeah, we're going to hear about that. We are 1,000,000% going to hear about that from the defense team who is busy papering the file with these big picture philosophical due process issues about cameras in courtroom. Okay. They're going to make a due process argument about the prosecution proffering falsified evidence. This is like a layup. This is a layup. This is a no-brainer. This is a dunk. This is so easy. We already have U.S. Supreme Court precedent from Napui and Glossip, cases that hold that prosecutor cannot rely on falsified evidence to procure a conviction. We already know that applies to trial. Not really much of a stretch to say, they shouldn't be able to subject somebody to the criminal justice system at all on the basis of falsified evidence. It's a fundamental due process violation to fabricate somebody and haul them in and get a fake, false finding of probable cause based on something that you knew wasn't true and was made up. That is such an easy layup argument to make, and one that just has a lot more legs, if there's anything to it, than at some day 10 years down the road, we're going to be saying Tyler Robinson needed a new trial because there were cameras at the preliminary hearing. Tyler Robinson deserves a new trial because they presented falsified evidence to bring him into court in the first place. A little more attention grabbing than, but the cameras and the unconscious bias. So guys, we're going to hear about it if there are any big problems like that. We haven't heard anything like that. We've heard that there's a mixture of evidence. We've heard that they were unable to identify or exclude the bullet fragments, the bullet jacket fragment from Tyler's rifle. So it's inconclusive, but certainly not excluded as being the source. And that's pretty much the best that they've been able to give us from a kind of weakness of the evidence sort of standpoint. This is what leads me to believe that the reason why we are not seeing a plea is because the evidence is likely going to result in a conviction. And so everybody kind of sees it that way. And so it comes down to whether they're going to take death off the table. If they don't take death off the table, then you have no incentive to plead. No incentive. You go through the process. Even if it's a slam dunk case and you're really super guilty, you go through that process. You make a strong mitigation case. Not going to be surprised at all if that ends up being where this case lands. It's sort of interesting, the sort of bigger meaning that cases have. You don't really see it at the time. It's something you only kind of know in retrospect when you see like how it unfolded and what sort of issues came out of it and how they were decided and what kind of impact it had for the future and things like that. And it's interesting to me that Charlie Kirk's murder so far, the meaning seems to have kind of coalesced around this issue of access and conspiracy and information and transparency and stuff like that, which are certainly very, very important issues. But one of the things that I think just hasn't really gotten talked about because we're not there yet. We might never get there. It's possible he could be acquitted. Of course, we're still early in the process. Don't really know that much. Just kind of hypothesizing based on what we already know. But hypothetically, pretty good chance that this case ends up being mostly about mitigation. And that's about grace. That's about grace and forgiveness and redemption. That's the part of the death penalty litigation that makes it different. Even though, yes, grace and redemption, welcoming people back to society after they have paid their price, giving people a second chance, somewhat surprisingly controversial ideas sometimes. And It's why we do them in the capital context. We do it, I think, a little bit more openly and explicitly because people do have very different opinions about, like, just can people sort of forfeit their right to redemption? Does everybody truly have the right and the possibility to be redeemed? Because the death penalty is the opposite of that. It is finding somebody irredeemable. And yes, there's plenty of people, probably still a majority in the country, as far as I know, that think that, yes, some things, some crimes are so bad that you forfeit your right to get a second chance. And, other people, probably the minority at this point, but still out there, think that everybody is or should be, entitled to a chance to redeem themselves. And I find it fascinating that maybe Charlie's case will end up kind of being about that at some point. But it's not there now. And I find that interesting, in part just because of how much overlap there is between that aspect of the criminal justice system and the Christian viewpoint, the Christian perspective, and this kind of conflict that we have between trying to do justice on the earthly level, and justice in a more, bigger, eternal kind of sense, and how we're doing what we do and how we treat other people, and what's for us to decide versus what's for God to decide. I feel like there's a real big opportunity in a mitigation, death penalty case for that kind of issue, to be very important to people, and to be just I guess an important debate to have. So we kind of continue to move forward to figure out what are our evolving standards of decency in society today, and all that. So I think it's not at all impossible that the real focus of this case for the defense is going to be on Tyler. It's going to be on him. It's going to be on, who he is, what his background is, how he ended up in this situation, thinking the way that he did. He doesn't seem to have the kind of history that you normally find in somebody who commits a murder that is going to potentially get them the death penalty. I just watched the thing on Netflix, an Untold, I think, last night about, now I can't even remember the guy, Wade Wilson, that guy with like the weird tattoos and stuff like that, from down in Florida, killed women, got the death penalty, got your kind of typical record that you would expect for something like that. A big long sheet of dysfunction and disregard for norms, social norms, things like that. These things that you look for with your antisocial types of traits. Tyler Robinson doesn't have anything like that, not overtly. And so, how did this happen? I think has the potential to be a very interesting and very important part of the case. But I guess it's because we have to get through, if it did happen, before that becomes a real viable topic of conversation. And of course, there's still a trial to be had. But even without that, just a lot of different perceptions about the evidence that we currently have. Lazy LCH, I would almost hope Erica would advocate to remove death penalty if it means faster resolution. Yeah, it probably would. It probably would. So typically in cases where, like in the federal courts, where Mr. Novak and Mr. Burt do a lot of their work, they often get appointed early in the process before there's a notice of intent to pursue the death penalty. Which is kind of standard. That's normal. Just because if it's death eligible, then under the standards that capital lawyers have to follow for what's effective representation, part of your job is to start your mitigation investigation so that you can lobby the prosecution not to file the notice in the first place. But so what often happens is they get appointed, and there's fair amount of litigation, and then the prosecutors ultimately decide they're not going to pursue it. And so what happens then is, okay, it's not going to be a death eligible case. We don't need these death qualified public defenders anymore. We go ahead and just remove them from the case and treat it under the standards that apply for representation of any ordinary felony, which is basically you are entitled to a qualified lawyer, and like that's it. So I could see something like that happening in this case for sure. If they took the death penalty off the table, we no longer have the need for the death qualified counsel. We're probably not going to boot everybody, but we also don't need to incur the expense of continuing to pay Mr. Novak and Mr. Burt for their expertise in capital cases in particular. And so, cut down on the defense team would possibly happen. And sort of the reality is, if there's less opportunity, less people doing work, then less work gets done. And if less work is getting done, fewer things are getting litigated. And if fewer things are getting litigated, then the trial is going to happen faster. So I could see something like that happening. But the death penalty, this is a controversial issue. Very, very controversial issue, kind of seeming to me to become more so, over time. Back in the 90s, don't feel like there was really a very vocal, a very large vocal group that would be anti-death penalty. I mean, obviously, there's always been abolitionists, but it seems like more and more people are kind of questioning the prudence, if nothing else, of having a death penalty for all kinds of variety of reasons. I mean, part of it, yes, the cost of doing it, the way that it has, it puts families in limbo because you have extended, the process so significantly. Like we just talked about, trial is over, but for, potentially decades, the family is still going to be living with the uncertainty of, so is this going to ever be final or not? And that's not necessarily therapeutic for crime victims and stuff like that. Concerns about the state getting it right. We've seen more and more situations, exonerations and things like that. Oh, I agree. Not every exoneration is a, actual innocence issue. But you don't get an exoneration most of the time without a pretty good, like a really strong showing that there was a pretty good chance that the jury could have seen it differently, under whatever circumstances. They weren't able to use the junk science, or they weren't able to use the coerced confession or something like that. Definitely not like, oh, it's, an easy thing to get an exoneration, because it absolutely isn't. But I fully accept that not every exoneration means that the person was actually innocent. Nevertheless, it's like enough questions that when, you're talking about putting somebody to death, it's extremely final, can't undo it. Should our government have that kind of power over people in the first place? Controversial issues. So I don't think it's, going to be resolved in a big picture standpoint anytime soon. It's going to continue to be a political debate. But in terms of this particular case, I don't know Erica's position on the death penalty. I don't know, her position on the kind of pragmatics of the trial process, and whether she even has a kind of good perspective on what she's going to be expected to endure if this, continues to go forward as a death penalty case. it's not her call anyway. You know, yeah, it carries weight. I would expect it to carry some weight, but it's up to the prosecuting attorney at the end of the day. Yeah, these are messy cases. None the Wiser has joined the channel. Welcome. Welcome, None the Wiser 1163. Is this YouTube doing the thing again where it like puts the numbers on people's names when it shouldn't, but it does for some reason. I don't know why. Oh, I see the chat is vigorously discussing the facts of the case yet again. Yeah, there's a lot of disagreement about this case, no question about it, and a lot of things that just aren't going to be resolved until we know one way or another what the facts are. Mary Ann Thorson, Mary Ann, welcome to the channel. So good to see you. Mary Ann is one of the Johnny Depp OGs. Love you, girl. Good to see you. Well, I think I rambled on a little bit more than I intended to on this one, but that's okay. That's what happens. That's what the chats and everything are for. And look, there's still 725 of you sitting here listening to my random thoughts about the death penalty and stuff like that. Miss Riz, can you do another live stream where we can come on and talk about our opinions, maybe, because something's got to combat this Candace Barron, Carol grifting nonsense? You know, I'm really kind of in the camp of I don't pay attention to stuff that isn't really happening in court, and I don't like to blow things up or treat things as more important, than they are. People can, like, my view is just people can kind of decide for themselves what they think about the evidence and the case and stuff like that. And not everybody is going to agree with me, and not some people will and some people won't. I just have one opinion in all of this. My opinion, as I say repeatedly, is just based on having done this work for many, many years. I have a perspective on it and on what I'm seeing unfold that is maybe a little bit more in tune with the strategy that the lawyers engage in, and just the patterns that you see, in how cases unfold and stuff like that. But my opinion isn't definitive, and my opinion also isn't fixed. I remain to be convinced by what actually comes out in evidence. It's just that from where we sit right now, and with what the parties have told us about the evidence, it looks a certain way. But that's just based on where we are right now. So I'm not really into like people can talk. I'm in favor of letting people talk. That doesn't mean I need to platform anything in particular, but it's kind of on par for me with, like, one of the arguments for the First Amendment is that I don't want to shut down speech I don't like. I want to be able to identify who those speakers are so that I know, oh, I don't need to listen to what you have to say. Your speech is low value. It doesn't matter. I don't really want to shut it down, because then, people wouldn't know. I like people to say their deepest, darkest thoughts, to say the worst things that they think of, reveal themselves through what they have to say, because then we can make informed decisions about who we want to associate with and how, and all of that. So, debate it all you want. But no, I'm probably not going to host a live stream or anything like that to talk about stuff like that. It doesn't matter to me. The court process is really what I am focused on and what I have the most interest in. And because if there is stuff that has merit, The whole structure of the court system is to create incentives for one party or the other to bring it to our attention. So if there's something to work with here, we're going to hear about it. And no, I'm not buying the defense is going to be in on it. We're going to have have a lot more comprehensive, explanation of who and how and why and so forth before any of that has any credibility with me. So, yep. Raguso, I agree. If the defense had cards, they'd play them. We understand the nature of the defense based on the cards that they are playing. We can see their game. There's nothing hidden about their game. They are playing the game in front of our eyes. And so we are seeing what their cards are. And their cards are, we need to make these due process arguments that are based on policy and really far-reaching vision stuff about how we might be able to convince a future federal court that having cameras in courtrooms in criminal cases is inherently problematic. That's the card that they have to play. That is interesting. For me, the lawyer, it's an interesting card. It's the kind of card that I expect capital lawyers to play, but it is very much not a he's factually innocent card that they're playing. They are not and have not played a factual innocence card. To me, that's telling. It's not everything. Of course, it's not everything, but it's just that I really notice when the factual evidence card gets played. Okay, when Richard Allen's attorneys came out in the press conference, like right after they were hired, issued a press release, be like, yeah, he's innocent. He didn't do any of this. Gets my attention. Brian Koberger, same thing. Defense team going on the record saying, we firmly believe he's innocent. And pointing out, here's the evidentiary problems. I take that very seriously. Makes me look at it and think about, they kind of got a point that there's a lot of stuff that I would expect to be here if he was guilty. That's not here. Not zero saying he did it, but definitely not an overwhelming. Very circumstantial, very thin. Not a lot of the layers, multiple layers of corroboration like you have in this case, seemingly like they had in cases like Rex Heuermann, Long Island serial killer, where it's like his emails are corroborated by his cell phone, corroborated by the dates when his wife and family would be out of town, corroborated by his travel records. Just corroborated by DNA, layer upon layer upon layer upon layer. Didn't have that, Brian Koberger's case. So when the defense is saying, I firmly believe he's innocent, it's going to get my attention. But we haven't heard the remotest peep of that in this case. It's telling. They're not playing that card. They're not even playing a card at this point that anticipates that they might be able to play that card. The reason why you wouldn't play a factual innocence card is if you aren't sure you're going to be able to back it up. You don't want to set people's expectations that there's going to be some bombshell, or there's going to be, some, some issue, some misunderstanding, whatever. You're not going to want to get people to expect that if you aren't confident you're going to be able to deliver that. So, it isn't just that they aren't playing it, kind of indicates maybe there's not a lot there to work with, but also that they don't even really necessarily anticipate coming up with a lot. That's why I don't think this is going to be an innocence case. This is going to be a mitigation case. That's what I expect based on what we know right now. Could change. That's where I see the case going. And that's where I think the defense is really going to be putting most of their efforts in the case. Is not did he do it or not, it's should he die for it. That's what I think the defense is going to be focused on. But of course, we'll see. It all remains to be seen. All right, guys, enough rambling for me. We're a few hours in now, so gonna check out. Gonna check out summer day, guys. I'm kind of throwing myself into summer. I didn't take my winter break this year. Last couple of years I took some time, went down to Patagonia and stuff like that. So I got a little summer and winter, a little extra outdoor time and stuff like that. I didn't do that this year, but so now I'm like extra craving, wanting to go on my hikes and get out and do things done and get my garden all tuned up and all those wonderful things. So I'm throwing myself into that with full abandon now. It's June. It's June, guys. It's June. I can't believe it. It goes so fast. So I haven't been on the tubes much, as I'm sure y'all have noticed. And, not trying to like neglect anything, but just have some other priorities at the moment. So not doing a whole lot, but I will be back, as I said, on Friday for Mickey Stines. If you want to check in on that, it will be a good time. And then the following Friday, the 12th, we'll have this follow-up hearing in the Tyler Robinson case. So I will be live for both of those, if nothing else. Continue to monitor the docket and add things into that legal archive as I find them. If there's, really important new cutting stuff, then I will often tweet about it. So you can definitely keep an eye out for that if you are interested. But otherwise, no promises that I'm going to spend my summer online, guys. I might have some more analysis, some more things to say for you, or I might not. I've just decided I'm not going to make any promises or commitments at all beyond I'll be here this Friday and next Friday, and otherwise we're just gonna kind of see how it goes. So with that, you know where to look for the new developments. You know where to find me. You know the things to do to be able to find me in the future, should you be inclined to do so. So do the things if you would like to do the things. And in the meantime, just going to continue to keep an eye out and look at these cards that are getting played. And I continue to evaluate this game, what I see unfolding in this game based on the cards we see being played. But I do appreciate, as always, all of you being here. Never ceases to amaze me, overwhelm me, humble me. How many people are interested in my sort of random ramblings about the criminal justice system and what it's like and all that type of thing. So it's just an very important part of our process. And this is one of those cases that I just knew from the beginning, because of who this is and how this happened and how many people were affected by this, there's going to be a lot of new eyes on the criminal justice system that haven't really had reason to pay that much attention to it before. So a lot of opportunity for kind of sharing my thoughts, my experiences from a good long time in the trenches about how these things go and what it means and all that. So just hoping we can make the process a little bit more understandable for folks who might be sort of new to it. So thank you all again. Thank you, mods. I know always have a busy job. Anytime we have a Tyler Robinson hearing in the case, mods get a lot of work to do. Not because we have anything against contrary opinions, but some people don't know how to debate their opinions in a respectful way that is courteous to others in the chat and respectful to others in the chat. So do appreciate the mods holding down the don't be an asshole rule. It is a very important one here. And yeah, appreciate everybody's interest in the case and in seeing that justice is done, whatever that looks like to you, or whatever you envision that is. It's an important value to have. How we get there and sort of what the facts are, what the evidence is, and everything that gets us to that point, still a little bit opaque, still a lot to learn. And so I see it as kind of natural that there's still a lot of question and just dispute about the meaning of all that type of thing. And that's normal because we don't know. We're in a place of uncertainty. But the cure for that is patience. And it's just the nature of these processes. They don't happen overnight, but give it time, and a lot of these questions will be answered. So thank you all. Appreciate you guys being here. Hopefully I will see you soon this Friday for Mickey Stines, following Friday the 12th for our hearing in Tyler Robinson. Guys, get outside, enjoy yourselves, enjoy your life, enjoy summer, enjoy the long days, the energy you get from just the life part of our seasonal cycle. It's here for us. I like to suck everything out of it that I can. Not like your mom, but anyway, go enjoy some, guys. I will see you next time. Appreciate you all. And take care. See you then.